Hello, and welcome back to Defense Diaries. I'm your host, Bob Mata, and this is our third live of the day. We are waiting for Kohberger to start. I'm going to pop this up just so you can see. Woo, look at that. It's coming. It's coming. We'll begin shortly, so I'll keep an eye on it. Got it live. Super, super live. So we'll keep a close eye on that, and we're waiting for Richins. So I'm going to pull that up. They should be coming back any second. I think they said they were taking an hour. I think. So let me pull this guy up here. Might even get Allie back. I hear her down there, being all sweet and cute with the dog. So adorable. So adorable. All right. So we will wait. We will wait. I'm going to keep Kohberger here on my screen so I can watch it. As soon as that thing goes live, we're going to switch over to it because I can pick up the balance of whatever we don't hear in the Richins case after the fact. Maybe we'll listen to it tomorrow. I definitely want to hear these arguments. It's very, very interesting. Ooh, Kaylee, what dropped in Reed? I'm not even sure. Tracy, did you get it yet? Tracy, have you sent it to me yet? I definitely have not seen that, but I will definitely, yes, we will be covering it. You mean something after them trying to get rid of Green and after the state trying to get rid of Rensselaer and Wolf? There's another one after those two? I'm assuming yes. Yes. A lot of Bob today. Very, very true. There's a lot of Bob today. A lot of Bob. Ooh, big motion. Dang. All right. Whoa, bombshell motions. Filed by whom, people? Tell me. Commonwealth or defense? Oh, boy. I can hear Scout all hysterical down there. Oh, the defense. Oh, the defense. All right. No, but I'm sure I'll get it. Yeah. Okay. All right. So keeping an eye on that. Don't have anything. They're still not back. Got a friend in the courtroom over there for Richins. I'm asking if they are back in the courtroom yet. Find out what's up there. Did you guys have a nice little break? What'd y'all do? Oh, what? No spoilers. Suzanne, you ruined it. Destroyed the evidence. Oh my goodness. Well, I mean, The defense still has to have their copy of it, don't they? Right? Wow. Wow. Oh, did you get a positive uh did you get a positive result, I hope? Meaning you're all good? Gosh, I hope so. Hope so. Yeah, going to the doctor is never fun. It's always get that element of terror. The older you get, the scarier every doctor's break or every doctor's appointment you go to is worse and worse. You oh man. Oh, so you you were on the job and you went and just did your due diligence. That's yeah, wow. That's good. That's good. All right, still nothing popping. Nothing popping yet. So I saw, yeah, lots going on, kids. Lots going on. So I'm sure Tracy is furiously digging to find the most recent motion filed by the defense and read. There will be some reading for this evening that I will definitely check out. Oh, I see. I see what you're saying. So they're trying to authenticate the original video and they have what? Destroyed it? Boy, wasn't there I would have assumed that there Kohberger, this it says the public portion of the hearing will begin shortly. I have it up on my second screen. I'm looking at it. You have my word. As soon as that goes live, I'll interrupt the Richins hearing if that even starts before this goes live. So we'll find out. But I'm gonna pivot. I'm gonna pivot over to Kohberger because we're supposed to hear arguments. So that's from what I understand. What we weren't hearing was the discussion, the actual the actual motion itself, wherein theoretically witnesses were called, experts were called, the discussion of what the evidence is or is not, where that all took place. And now we're going to, theoretically get to the legal arguments where they're probably instructed not to mention specifically what the evidence is because that's what they're trying to keep us on the dark about, which is frustrating. It's becoming a bigger and bigger trend, a bigger and bigger trend. And, I mean, social media, it's a blessing and a curse. It's a blessing and a curse. It's becoming more and more prominent for judges to seal documents, for them to have closed hearings than it ever was before. And that it is a direct result of coverage. People like us and all the other law tubers out there that are watching and listening carefully as to what's going on in our courtrooms all over this country. So we're getting shut out more and more often. Not a fan. Not a fan. Like, cause they have to meet a very high burden in order to, but leaning on that fair trial aspect, it's powerful. It's powerful. And it's like the downside for a judge ruling to have a closed hearing more likely than not is rarely, if ever, going to result in a new trial for a defendant. So it's a low risk proposition, but I don't like when cases are tried in the dark. I don't like it for myriad of reasons. And it's the trend. It's trending that way heavily in a lot of cases, a lot of them. I mean, if we don't have the ability to trust that potential jurors are going to be truthful during voir dire, when they're questioned as to whether or not they know about the case and what they know.
All right, folks, we are back on
wrap
the
up.
record. The WebEx audio feed is unmuted. Mr. Bloodworth, the state's next witness.
Thank you, Your Honor. Your Honor, the state calls Detective Jeff O'Driscoll.
We'll get Detective O'Driscoll sworn in.
Do you solemnly swear the testimony you're about to give in the matter before the court to be the truth, the whole truth, and nothing but the truth, subject to the pains and penalties of perjury?
Yes.
Thank you. Proceed.
Detective O'Driscoll, I want to turn your attention to and discuss your interaction with the defendant on April the 14th, 2023. Do you recall that day?
Yes.
At that point in time, what was your relationship with this case?
I had just been assigned as the lead investigator on the case. I was not familiar with all the details of the case. I was trying to get a fresh perspective and pretty much starting from scratch.
And as part of your start from scratch, did you want to introduce yourself to the defendant?
Yes, I wanted her to know that there had been a change, not only in the assignment of the lead investigator on her case, but there had been some supervisory changes to the investigations division as well.
And when you say her case, you mean the case at that point in time investigating the death of Eric Richins?
Correct.
What was the change to not only you as the lead investigator, but you said, I think, the supervision of the division?
There was a new sergeant over the detectives, the investigation division, Sergeant Hoffmeyer.
So I take it you determined to then personally call on the defendant on April the 14th, 2023.
Correct.
And why personally instead of over the telephone?
It had been a year since Eric's death. I felt it was more professional considering the loss that she'd gone through in the family, and felt that it was more appropriate to show up in person to speak with her and to introduce myself than over the phone.
Okay. There came a time then when you appeared on the doorstep of the Willow Court home where she was then residing. Is that correct?
Correct.
And thus began your interaction with her on that day, right?
Yes.
Did you record that interaction with her?
Yes, I did.
How did you record it?
I had a audio recorder running, and then later I activated a body cam that I had with me.
Okay. Let's talk about the body camera. When did you activate it?
After we were invited into the home and asked to sit down.
And did you activate it roughly contemporaneously with the point on the body cam, or the point on the recording where you say, do you mind if I record this interview, or something to that effect?
Correct.
Can you please describe the body camera, not only how the body camera itself looks, but where it was sitting in relation rather to the defendant?
Yes, I wasn't dressed in a law enforcement uniform, and so I didn't have a mount that's typically available to officers to mount their camera to their body. I just had it loose. It's a small square black body cam that's similar to those worn by patrol officers at that time. And when I activated it, I sat it on the armrest of the couch between myself and Miss Richins.
Was it in Miss Richins' plain view the entire time it was active?
Yes.
Does the body camera itself make any noise or light?
Yes.
What noise or light does it make?
It beeps and vibrates every few minutes, and there's a red flashing light that also indicates that it's recording.
And would Miss Richins, the defendant, have been able to see from the location of the body camera vis-a-vis her, the blinking red light, and hear the vibration and beeping?
Yes.
You mentioned it was similar to body cameras that officers on patrol wore at the time. Was it similar to the body cameras that the officers on patrol were wearing while they interacted with the defendant in the early morning hours of March the 4th, 2022?
Yes, at least some of them were wearing the same body camera.
Have you reviewed both the audio recording and the body camera recording that you
Okay.
made?
All right.
day?
We're going to interrupt it. We're going to interrupt it and switch over. All right. I'll have to go back. We will finish it. But as promised, they just came into the courtroom on Kohberger. So we are going. All right. Now,
We are now, I believe, streaming. For the record, the defendant is present together with counsel, Ms. Taylor and Ms. Massoff. The state is present and represented by Mr. Thompson, Mr. Nye, and Ms. Jennings. We are now going to hear argument from the parties on the Frank's motions filed by the defense. That will include the Frank's hearing that was held on the IGG issue, as well as the defense's proffer as to the rest of the Frank's issues as to why the court should hold a hearing on those matters. We're holding an evidentiary hearing on those matters. Am I missing something we talked about?
Your Honor, I may have missed it, but I thought we were offering argument on suppression IGG.
Well, the suppression IGG, we can also argue that. I think it's wrapped up in the same issue. I thought we were going to Frank's next.
I did not. I apologize.
No preference over here, Your Honor.
Well, do you want to argue suppression on IGG and then we can do the Franks? That's fine.
I would need 5 minutes to get my Frank's items ready.
Let's do argument on the suppression of the IGG related matters, and then we can then hear the Frank stuff. That's fine. If that's what you're prepared to argue.
Thank you.
Go ahead.
Your Honor, our position is that the court should suppress the IGG identification and everything that flows from that. This is supported by 4th Amendment of the United States Constitution, due process, Article 1, Section 17 of the Idaho Constitution. Your Honor, there was no warrant for several phases of the search that led to the IGG work, investigative genetic genealogy. And we think every single one of those stages, a warrant was required. None was given, and so this must be suppressed. Your Honor, I'd like to identify the 3 stages, and they are when Idaho State Police Forensics Lab, through Moscow Police Department, moved a DNA sample to Othram Laboratories to develop a profile to run through genetic genealogy investigations. There was no warrant for that search for a SNP profile that could be used to attempt to identify somebody. The next stage would be when that was transferred to the FBI for their forensic investigative genetic genealogy work to try to identify somebody. No warrant was in place for that work either. Finally, there was a trash pull in Pennsylvania, and there was no warrant for that trash pull either. All 3 of those stages of this case, there should have been a warrant and there wasn't, and this must be suppressed. Your Honor, for the purposes of the 4th Amendment protections and Article 1, Section 17 of the Idaho Constitution, we are looking to see if somebody has a privacy interest that society is ready to support. In this case, if society is not ready to support suppression of every bit of our DNA when the government does not have a warrant and searches it, there is no privacy right left.
Do you have any cases that hold that?
I do not have any cases that hold that, nor do I have any to the contrary that say that's not the case. Your Honor, this is a situation where this identification was done in complete secret behind closed doors, and it's been continued to be a secret. And that should raise red flags for Your Honor about privacy interests that are at stake. The court can see from the various affidavits in this case that there's a lot of things done that don't say how Mr. Kohberger was identified. And the reason for that is because nobody wanted to talk about what happened here with the genetic genealogy. That search was done by making a profile in Othram Lab. That search did not lead anywhere. The FBI took over the search, and from there they did things that we have no idea what it is. That entire segment of this case is secret. We have been through several motions to compel to try to get information, and we've gotten very, very little information. The court should know that we learned today about policies and procedures of Othram that we have not been able to take a look at. Those have not been produced. In fact, we've been told they don't exist. We learned about investigative work that was done after Othram had done the work that they could do and before the FBI took over, that we learned about for the first time this week. Not through the motion to compel process. This was a giant secret. When we get to the FBI, we don't know who did the work. You heard that any of that information is redacted. We don't know who did the work. It's a giant secret. We know that by the time the FBI gets involved, the profile, the text file, that's a snip to use to try to identify somebody is more than twice as big when it gets to the FBI from Othram. We don't know how. We don't have any notes. We don't know who did any of the work. We don't have any lab protocols. We don't have any quality assurances. It's not reliable.
You're not asserting that Mr. Kohberger's DNA sample was uploaded into any of those databases, that his was, like, for example, his own DNA was one that was matched from the crime scene. Not asking whether the crime scene DNA was uploaded, but whether he had, as a, for example, customer of one of these companies, uploaded his DNA.
Well, Your Honor, I don't have the jed.com file. I don't have,
You're not asserting that fact, correct?
Your Honor, I'm not sure what the court is asking me.
Well, it goes to whether or not your client has standing to complain about the searches of the databases, because as the state has posited, that wasn't his DNA that was searched. At best, it was his ancestors.
Well, Your Honor, I am not sure why we're here if the state hasn't alleged that Brian Kohberger's DNA was on the knife.
No, I'm not talking about the knife sheath DNA. I'm talking about what they tried to match it to.
Your Honor, I would answer it this way. The way that those databases work is looking for shared DNA. Those databases don't churn out a name and say this
I
is
have
your
a
suspect.
privacy interest against any of my relatives that might want to upload their DNA.
Yes,
To
that's what I'm arguing. Yes.
systems. I should be able to stop them. from doing
Yes.
that because I share some DNA.
No, you should require a warrant.
That is certainly not what I'm saying. What I am saying, Your Honor, is if somebody takes your DNA and uploads it, I think you have a privacy interest in your own DNA.
Not necessarily in, let's say my DNA is taken lawfully. What privacy interest do I have in the search of the DNA of others?
You share DNA with your
That's a loaded
your mayor
question.
heirs.
Why is it a
Male
loaded
heirs,
question?
I
Isn't it
mean-
a factual question?
This is
Well,
all first
It
impression.
is, Judge, but you're assuming that the DNA was taken lawfully, and our position,
I agree that part was, is an assumption. In my hypothetical, I said my DNA was taken lawfully. Why would I have standing to object to the search of other people's DNA simply because I might share some genetic information with them because they are distantly related to me?
well, Your Honor, our position is that this work was not done lawfully, that it was unlawful, that there needed to be a warrant, that this was done outside of a warrant. And I'm not asserting on behalf of anybody else in this, any relative, anybody who might have been named or not named. This is about an identification process. It needed to be a lawful process. It wasn't a lawful process. It was in violation of Mr. Kohberger's rights. I don't know how he cannot.
How
have
was it in
standing when
violation
he's
of his
accused.
rights?
Excuse me?
How was it in violation of his rights?
Well, Your Honor, he's been in custody
You're
for
saying
2
that,
years.
I understand your position, which frankly is not well supported in the law, that if hypothetically here, he went to this crime scene, committed these murders, and left DNA on a piece of evidence, that he now has the ability to object to that evidence being searched for identification purposes. There's no case that suggests that, that concludes that. And it seems to me to be an extreme position to take in light of the case law, and I'm trying to understand how you get there.
Well, I think Your Honor is asking me about things that I anticipated the state would argue, their abandonment theory. And I would remind the court that the Ross case said that abandonment is a knowing intentional leaving of something, for one thing. For the other thing, I think that the court is asking me to take a position where it feels like burden shifting to me.
No, I'm trying to understand the legal argument and how this is different from example from latent fingerprints.
Well, Your Honor, I think that things like latent fingerprints and like CODIS, there's statutes about CODIS in Idaho, about what's allowed in CODIS. This is a different search. This isn't an STR search. That's what happens in CODIS. This is a different
So
search.
I'm going now to, I'm sorry, the constitutionality of using the DNA that was allegedly on the knife sheath. And because I understand your argument is twofold. One, your client complains that a search was done of databases of other people to determine whether or not any of them might be related to the person who left the DNA on the knife sheath. That's thing one. Thing two is an objection to the law enforcement searching the DNA by testing it and getting a profile from the knife sheath without a warrant. My question goes to that latter point, understanding the basis for that, because I can't find any case law that would support that idea, that somehow a warrant would be needed for DNA left at a crime scene.
Well, I think in our briefing, Your Honor, that we cited the court to some cases.
I did, I think, one concurring opinion in a case that held otherwise.
Your Honor, I was going to talk to the court about third-party data, and I was going to talk to the court about the Davis case that talked about something that the police lawfully had and a subsequent test, the Skinner case, when there's something that's lawfully held, but there's a subsequent test. So those are the things that I want to talk about. Our first point is it was an illegal search. And this is if
The
for the
search, which
court's
search?
assumption,
Which search? It was illegal.
well, first the snip at Othram, then the snip at the FBI, and then the trash pool.
So you're talking about the DNA testing of the material left allegedly on the knife sheath.
I'm talking about the Idaho State Police Forensics Lab taking a piece of evidence given to them by Moscow Police Department, collected at the scene, developing a STR profile, uploading it into CODIS, and I think that's the King case that says that's fine. I know Idaho has statutes on CODIS, uploading it there and producing nothing. There are no results there. I'm talking about the next set of moves that are super secret, that happen when there's a portion of the DNA taken and it's searched by Othram to create a SNP. And then when that doesn't produce anything, the FBI says, okay, here we go. Let's search the SNP ourselves. That's what I'm talking about.
I'm
Though,
not seeing it.
as far as inserting family,
Specific DNA tests done of the sample that goes from legitimate to illegitimate?
yes, Your Honor, I think the Davis case is on point. If the court's theory that this is a lawful piece of evidence taken from the crime scene, the sheath,
Not my theory. I'm just trying to understand your position in light of the case law and in light of the state's arguments. I'm trying to
Wrap
find
my mind around it.
Bristol is in this.
I'm adopting the court's hypothesis for this purpose, that the knife sheath was taken. I'm adopting it only for that purpose, and I'm relying on the Davis case that says subsequent searches need a warrant.
And remind me, Davis was the cell phone?
No, Davis was not the cell phone. Davis was blood, a sample with blood. The cell phone case is
Give me the
Carpenter.
site to that.
I'm sorry?
Can you give me the site to the Davis case?
I can. Give me 2 seconds. 2 seconds and glasses.
The dreaded age of the glasses. Oh my goodness, I get to do this right
My
now.
memory
Hold on.
tends to be fact-based and not name-based, and so that's my
Where is it?
liability.
Well, it's going to take me just a second. I apologize.
Bob, you're muted.
I apologize. I wrote the
You
name
can't
down,
pause
but not the
this
site
feed
in my
either.
notes, but I know it's cited in our briefing. I can't remember what page. Ah, it is 690 F 3rd 226.
Okay. Go ahead.
All right. And so those are the 3 areas that we believe that there should have been a search warrant and there wasn't. There is an expectation of privacy in one's DNA that society is willing to recognize. And I think I'd talked to the court a little bit about the things that happened in this case that were super secret. I think we'd gotten to the point where we were talking, and this goes to recognizing an expectation of privacy when there's all of this secrecy surrounding it. We had gotten to the FBI where the SNP profile was twice as big as that from Othram. And then the FBI went into databases that violate the Department of Justice interim policy. You heard a lot about that Department of Justice interim policy, and that policy it's on page 6 of that particular exhibit that the court has. It says that they're not to go into databases that aren't allowed. And they did that. The court has that in another exhibit.
How's that a constitutional violation?
Your Honor, it goes to privacy.
Don't suppress for contractual violations or even statutory violations.
I'm not suggesting that we do that. I'm suggesting that that's information that's pertinent to this court in making a very important decision as to whether somebody's Fourth Amendment rights were violated, as well as Article 1, Section 17 of the Idaho Constitution. The purpose of offering that information is because there's a policy, so there's there's a recognized expectation of privacy in what's contained in a SNP. In a SNP at all, there has to be a warrant to search these types of things, and there wasn't. There would be no need to have any policy if nobody cared about this. The court heard about the different IgG databases that changed their rules in terms of use after a different case used IgG to solve it because people don't expect to have their DNA searched.
That was the point of my question about whether or not Mr. Kohberger's DNA was in any of those databases.
Wasn't.
In other words, did he submit his DNA and said, I don't want law enforcement to look at it?
Your Honor, I don't think that that's the way the question should be looked at. I think the question should be looked at is in the way that we always look at warrantless searches.
Got to be a standing.
Your Honor, we're here because the state has alleged that a single piece of evidence ties Mr. Kohberger to this case. They've alleged that there's a knife sheath that has DNA that they allege matches Brian Kohberger. He's now been incarcerated for 2 years, facing capital murder. I'm not sure, unless we're shifting the burden to me, what else I can say.
Well, you have a burden of showing that the
He's got
items ought to be
standing.
suppressed.
Under
This
the
is a
current law,
warrantless search.
he doesn't have
There's no
standing to make the
justification for
argument
this
that
search.
he's got a privacy interest in.
Well, that's what I'm
Warrant
saying.
required for this type
She's got
of
the burden to show the standing.
Inquiry.
It's going to have to go up to
Well,
the
Your Honor,
Supreme
we think
Court.
it
She
is,
can't
and we
show
think
it. It's
is
not what the
based
current
on
law
case
is.
law, third-party doctrine case law, that's Carpenter. Thinking about cell phones, that's the Riley case.
Because you and I have had this
If
debate.
you have a cell phone that gets taken at an arrest out of a car, a subsequent warrant to search the cell phone is required. So we think a warrant was required for these subsequent searches, and there was no warrant in this case. There's an expectation of privacy.
I struggle with, well, I struggle, to be frank, and where you're going to have to try to convince me, I guess, is I struggle with the idea that DNA left at a crime scene, that there's any expectation of privacy by someone who leaves DNA at a crime scene, that DNA can't be, as you say, searched without a warrant to establish identity.
Well, Your Honor, I don't think any of us can go out of our houses without leaving DNA all over the place.
Not go to a crime scene.
The question of how something gets somewhere, that's the subject of the trial. I think the Carpenter case is really instructive for the court here. And that case was about, it was about third party with cell towers. And there was a concurring opinion in that case. I think that's instructive.
Okay. And
We leave DNA everywhere. If you carry a cell phone and it uses the towers, there can be a trail of where you
Fingerprints
went.
everywhere?
I'm sorry?
Don't we leave fingerprints everywhere?
Fingerprints are
Leave
different.
fingerprints everywhere, but
I don't
would
share
say, Your Honor,
fingerprints
that
with anybody
things
else on the
like
planet.
your
I do share
movements,
DNA.
cell
okay,
towers, the contents of your
Keeps
cell
giving that
phone, those are really personal
analogy, and I
things.
don't like it.
That's
It
how
doesn't
you
make any
carry
sense.
out your business. That's how you go. You drive your car to go to the doctor. Your cell phone's heading on those towers. DNA is even more personal than that.
Thank you.
The tests are so different than they used to be now. It can pick up all kinds of information. It takes very little DNA. DNA lives on surfaces a lot longer than fingerprints live on surfaces. So without more, they're not much of an indication of anything. There's a warrant requirement to protect people from unreasonable searches. And that's what we're asserting here. There's so much information contained in your DNA, and you can't stop from shedding that when you go out of your house. None of us can. To be able to have that searched without a warrant could put anybody in jeopardy. There's no privacy left. If that's going to be the standard, you put it in public so it can be searched. That can't be the standard. That would erode the Fourth Amendment. Our position is that there is an expectation of privacy that society is willing to accept. Our position is that there's case law that supports this. Maybe not exactly directly on point, but the court talked about one of the cases that we cited that's similar. It's out of Washington. In that case, it keyed on whether the database was a voluntary, law enforcement can search this or not. In this situation, that's not the case. You know from the exhibit you have and from the testimony that you heard that the FBI went into 2 databases that they weren't permitted to search. So if the court wants to go clear to that extreme, and the court shouldn't, The court should look at the Fourth Amendment. The court should look at expectation of privacy. The court should look at the 3 places there was a warrant required and it wasn't given. But if the court wants to go all the way down to whether or not there was a database searched where the people consented to have their DNA searched, our case is different. The FBI went into 2 other databases and searched those. There was nothing else happening until that happened. And it's instructive, I think, and important for the court to think about how secretive this all was. We are months from trial and we are learning things about how the government identified Brian today in open court when we've asked for those things. There's a reason why there's so much secrecy. That's because there's a violation of privacy rights. That's why there's so much secrecy. Your Honor, this is an extremely important motion, and the court is going to decide whether we do have any expectation of privacy left or not. The IGG evidence in this case should absolutely be suppressed.
Well, you didn't convince a man.
I suspect the state's going to raise an issue that you may need to respond to, but I'll let you respond to that if they do raise that issue.
No standing.
Your Honor, thank you.
Which is the example
Honor.
Bob gave earlier, if you guys
Should I,
remember, about somebody dropping a gun at his house.
permit evidence obtained potentially by searching databases that by its own policies, law enforcement said they wouldn't search.
So a couple points on that. First, even assuming that that's all correct and that they violated the terms
Seems to be the evidence.
the terms of service, Your Honor, don't affect the Fourth Amendment. The terms of service, and certainly Mr. Kohberger does not have standing to raise a violation of the terms of service. And even if he did, the remedy for the terms of service is not a violation of the Fourth Amendment. As we argued in our brief, the individuals, and as came out in testimony today, the individuals who are utilizing these databases, and we're talking about millions of them, are willingly sharing their information with each other, with millions of other people.
Isn't there a subset that says, but I don't want these people to look at it?
In some of the data,
The FBI, as I understand the evidence, then says, okay, we agree, we won't search those ones.
so I'll address that part, but on the database piece, the issue is that no one sharing this information with millions of other people could have a reasonable expectation of privacy. The test for that isn't, do they have a reasonable expectation of privacy against law enforcement? It's against the public writ large. So for example, we cited in our brief 3 different cases where Idaho's appellate courts have found people have given up a reasonable expectation of privacy in information that was shared with a single company. And it was shared with that company just so they could get the service from that company. Here, we're talking about people sharing it not just with the company, but with millions of other people, because sharing it is the purpose of providing it to the database. So regardless of what the FBI did or didn't do in terms of violating the terms of service, no one has a reasonable expectation.
Is it different if they share it with the company and it's obtained by lawful process from that company versus going in the back window and taking it?
No, Your Honor, because right now what we're asking is not reasonableness of the search. Right now what we're asking is there even a reasonable expectation of privacy? And so the fact that no one has a reasonable expectation of privacy in those databases means that even if the FBI violated those terms of service, no one has a Fourth Amendment right to complain. And certainly Mr. Kohberger doesn't. He has not asserted factually or through evidence that he was a customer to one of these databases. And maybe that changes the case if he were, but he's not. He's not even claiming that. He's not even asserting it. Now, I do want to address the second part of the court's question about the FBI has indicated that they wouldn't do this. I believe that's a reference to the policy we've been discussing, the interim policy by the DOJ. I certainly do not speak for the Department of Justice. I do not work for the FBI. I'm speaking for the state of Idaho, but I can read a document. And if you look at the policy in footnote 1, it clearly says this interim policy does not impose any legal limitations on otherwise lawful investigative or prosecutorial activities or techniques utilized by the Department of Justice, or limit the prerogatives, choices, or decisions available to or made by the department in its discretion. In other words, their first problem is they're relying on a policy at all. The U.S. Supreme Court has said policies do not equal Fourth Amendment violations. Their second problem is it's a circular argument. The policy doesn't say you cannot do any of these things. It's saying best case scenario, you're not going to do these
Well,
things.
if you were interpreting this as a matter of contract, wouldn't you have a problem? In the sense that on the one hand, it says don't do this, and on the other hand, you've got a more general sort of catch-all that says, but we're not really meaning anything we say.
No, I don't think there's a problem interpreting that at all. I think the problem is they are putting way too much weight on this policy as if it's somehow the law, and it's not. It's indicating, and we heard testimony today about best practices and what those mean. This is indicating best practices, but very clearly stating we are not limiting the Department of Justice to have to follow what's in this document as long as it's not limited by the law. And they're trying to use a violation of this policy or an alleged violation of this policy to say that they violated the law. It's circular reasoning. But despite all of that, the U.S. Supreme Court has said a policy violation isn't sufficient. Even the Department of Justice, as powerful as they are, they don't get to rewrite the Fourth Amendment by changing this policy. Now, I do want to address the defense is they're trying to pick and choose what they believe the searches are throughout this chain. And what they're leaving out repeatedly is where this DNA started. Where did the chain start? Well, it started at a quadruple homicide, at a crime scene. There is no case law anywhere that the state could find, and the defense has not cited any to suggest that there is a reasonable expectation of privacy in DNA found at a crime scene. And I want to talk about the Davis case, Your Honor, because it actually cuts against the defense. Davis is the case where it was a very unique set of facts. There was an investigation into a shooting. An officer went to the hospital, and when he went into the victim's room, he saw a bag of clothing. He seized that clothing under the plain view exception to the warrant requirement. So the clothing wasn't abandoned. This was an exception to the warrant requirement. Later on, this individual who was a victim now becomes a suspect, and they have this DNA and they test it. And the Fourth Circuit said, no, you can't do that. You can't take it because he's a victim and then later use it against him as a suspect. That is nothing at all like what we have here. And in fact, if this court looks at the district court opinion that was affirmed by the Fourth Circuit, it expressly states nothing about this holding is indicating that the government needs to get a search warrant for crime scene DNA. That does not support their position. The Achilles heel in their entire chain argument here is that there is no case anywhere that suggests that a DNA analysis restores a reasonable expectation of privacy. So in the Davis case, no one lost their reasonable expectation of privacy. It was seized pursuant to the plain view doctrine. The other case that they're relying on is that recent Supreme Court decision from Arizona. They attached it to their reply. That case is similar to Davis in that the DNA was collected from someone who consented to it under a statutory framework because they had to provide 2 vials of blood so it could be tested for alcohol and drugs. Again, that case would have come out differently had the 2 vials of blood been found at a quadruple homicide. That is a pretty big factor in deciding whether or not someone has a reasonable expectation of privacy. In Idaho, while this specific issue has not been addressed by the appellate courts have told us what to look for when you're talking about a reasonable expectation of privacy. And it's things like ownership, possession, control, ability to regulate access. Mr. Kohberger had none of those things with respect to the DNA on the knife sheath. We are talking about not just a crime scene, not just a murder scene. We're talking about a murder scene in a house to which he has asserted no connection whatsoever. 4 victims to which he has asserted no connection whatsoever. We're not just talking about his DNA happened to be found in, a dresser drawer or something. It was found on a knife sheath where 4 people were killed by a knife. This is as crime scene as it gets. And that's where the DNA was found. And they can't cite any case law whatsoever. And so they try and just ignore that and skip over it and say, well, let's just talk about the DNA analysis. The other problem they have, as this court questions indicated, is the analysis that was done in this case, as we heard the evidence today, is not something that revealed a bunch of private medical information. In fact, the defense's own expert, who is engaged in the same kinds of conduct as Othram in terms of developing these SNP profiles, said he had successfully developed hundreds of SNP profiles and never once learned medical information about any of those individuals. He testified that he has never even heard of a forensic investigative genetic genealogy case that was solved using medical information. And in fact, and I wrote this down when I asked him what he would need to do to learn medical information from those SNPs, he said, quote, "It would be a lot of research." So the defense is positing this question of, they're saying the court needs to ask itself, what could law enforcement do with the DNA? And then decide whether or not there's a violation of the Fourth Amendment. But that's not what the US Supreme Court says. In Maryland v. King, they were very clear when it comes to DNA, because the defense there was asserting the same argument. We have DNA can reveal a bunch of private medical information, and the US Supreme Court said, quote, "Even if non-coding alleles could provide some information, they are not in fact tested for that end." So the question under the Fourth Amendment is not what could law enforcement possibly do with this? The question is, what did they do? And in this case, there is no evidence whatsoever that they did anything to find out medical information about Mr. Kohberger. It was all related to ancestry and identity. And as the US Supreme Court said in King, there is no greater privacy interest in DNA than in fingerprints, so long as law enforcement is limiting its activities to identification. And that's what we have in this case, is identification. Now, the other problem that Mr. Kohberger has here is, in my view, at least, he's been a little bit wishy-washy on the DNA on the knife sheath itself. You don't get to claim Fourth Amendment standing and then just say, well, that may be my DNA, but I have no idea how it got there. Again, the Idaho Court of Appeals has held in a couple different cases that if someone, for example, in one of the cases denied the existence of a bag that had been thrown out of the window, and the court said, well, you can't have a reasonable expectation of privacy in a bag that you deny exists. This is a very similar thing. We have a defendant who is trying to get the best of both worlds. He's trying to say, well, it's not my DNA and the state can't prove that, but he's also trying to say that he has Fourth Amendment standing. And that is not how the Fourth Amendment works. Your Honor, I also wanted to respond to an argument that was made in the reply brief, since I didn't get a chance to do it in the briefing. And this has to do with the trash pull in Pennsylvania. And I'll just start by saying that the defense has offered no evidence whatsoever that would take the trash pull in this case outside of the Idaho Supreme Court's decisions in Donato and Paluzzi. Paluzzi is very recent, came out in the middle of the briefing, in fact, and rejected the exact arguments that are being pressed by the defense here. Obviously, this court is bound by that reasoning. When the state pointed that out in their response brief, in the reply, the defense made an assertion that this case is different because the documents the state has provided are not clear on where the garbage cans were located, and that maybe the officers went up onto the driveway instead of collecting them from the street.
Trash company collected it.
Correct. I'm sorry, Your Honor, I misspoke. The trash company collected them on behalf of the officers.
They just did the regular pickup, I thought. And
Correct.
pulled over after they got out of the neighborhood and said, here's what we grabbed.
Well, I do believe it was prearranged with the FBI for them to do that. But my point is just, I do think it's telling that they didn't provide the court with these documents that they believe are not clear. And I looked them up to make sure that they were. And in fact, there is an FBI report that was disclosed in discovery that details that the garbage cans were at the end of the driveway, at the end of the property. And at the end, it says, see video. And there was a video disclosed in discovery where you can see the officer's body cam as he drives by the house shortly before they look in the garbage cans. And they're in the exact place you would expect garbage cans to be when they're out for collection. So they, of course, have the burden of establishing a search. They haven't presented any evidence to that. It's not sufficient for them to stand up here and say, well, it's just not clear. Which brings me to my final point, and that is Ms. Taylor continues to say there was a lot of secretive stuff happening in this case. That is not sufficient to satisfy their burden that there was a search, that someone had a reasonable expectation of privacy. When you have the burden, you have to present evidence. You don't get to just stand up and say, well, it was very secretive. I will note in this case, as the court may be familiar with it, as it's probably read back through the record, the defense in this case has gotten a lot more information than many defendants in other states who have, where there's been an IGG investigation, because the majority of courts have found this isn't really relevant information. It's just a tip. Now it is what it is in this case. And we of course complied with all the court's orders and provided the information, but there's not a lot of information, not because it's secretive, but because it's just not our case. It's not what we're focused on. It's not the evidence we plan on using at trial. And yes, IGG was used in this case. And yes, it did point to the defendant. But the fact that that happened doesn't mean that there was a violation of the Fourth Amendment. Unless the court has any questions, we'd ask you to deny the motion to suppress.
If the FBI in fact violated the Fourth Amendment rights of Mr. Kohberger, you would agree the state is burdened by that?
Leave that one there for me.
That's a great way of putting it, Your Honor. Yes, the state would be burdened by that. Yes.
Well, he just left like that. Didn't see where the judge was going.
Oh, he said he
But,
was done.
Mr. Hercules did, or Mr.
I'll
Heracles.
start backwards. I
Or am I
will
butchering that?
answer the court's question that the court posed to Mr. Nye. The state is burdened by what the FBI did here. Every action the FBI took in here, all of the secret actions that they took, show you that there is an expectation of privacy that society is willing to accept. They didn't want anybody to know what they're doing. It is interesting to hear that discovery requests and motions to compel and orders have been complied with, when I've learned at least 3 new things in the course of preparing for this hearing and being at this hearing so far today. That's a surprise to me. So I wanted to say that, and I want to go back to the trash pool. And I want you to know, when you consider this, that that particular area had an ordinance that trash had.
Supreme Court reject that argument very recently.
Your Honor, they might have, but that ordinance isn't all. I was starting with the ordinance, that it has to be collected by a trash collector, that a certain trash collector, and that you have to put your trash out too. In that circumstance, the FBI worked with the trash collector and had them go just to get that trash and then take that trash somewhere else too. And those are some extra actions that the FBI took in this particular case.
They're agents of the
How
state.
does that change the analysis?
Well, Your Honor, I think that it changes
The
the,
expectation. of
You're a little
privacy
late. Our
lost
commenter said that a while ago.
Who?
To be taken away.
It's literally still up. I asked that it be stay up.
Regulated neighborhood
Oh.
ordinance that says when and where you
I
have to
didn't
put
see
your
that.
trash.
well, Your Honor, I think that there is an expectation of privacy when you have to comply, you have to put your trash out in that particular manner.
Not the case.
Everybody has to put
And
their
but you're
trash
saying the
out.
Supreme Court was wrong, the Supreme Court was wrong, and you're reserving that for a later higher appellate court. That's fine,
Your Honor, I may not always agree with the Idaho Supreme Court on everything,
but I have to follow what they say.
but I have to make a record when I don't agree.
I appreciate
with
that. I'm
what's
just trying
happened,
to make sure we're talking about the same thing.
and I have to distinguish the case as best I can as well. And I think it is different when you have the FBI telling the trash man what to do. I'll move on to something else. I want to talk about now where Mr. Nice started that Department of Justice interim policy, and he read you the first footnote, and I would just direct the court to pages 6 and 7 in that, and that is that the FBI is not to search databases that they're not allowed to. In this case, the 2 of the 4 that they did. And the next page talks about the things that have to be kept in case there's a prosecution case. the prosecutor talked to you about, well, this is a tip. This is just a tip. It's like an informant. And it's thought of in this Department of Justice policy as more if they're told to keep things in case there's a prosecution case. And so that should be considered when you're considering the entire picture that we have here in light of the amount of secrecy that happened here. That takes it out of being a tip, it takes it out of being a lead in the case. I would remind the court, I'm sure the court knows pretty well when we're talking about confidential informants and that type of law, you have to have some reliability. And there should be a big question here about how reliable this is, how reliable whatever it was the FBI did to develop this profile with the rest of the secret things that they did in this case and their willingness to violate their own policy. Certainly not suggesting that this court create a new Fourth Amendment right based on violation of Department of Justice policy, but I'm saying you should look at that and consider that when you're thinking about what the FBI did here and how credible this informant was, how credible this lead was in this particular case. That's fair for you to consider, just like you would in any other confidential informant type of case. I would like to distinguish what we have here with our subsequent search. I talked a lot about that before. I won't go too far on that. This is a second search and a third search if we're just focusing on the 2 SNP files. These are extra searches that happen after the initial search is done and the STR profile is developed and it goes into the CODIS database. This is completely different and a SNP is different. You heard a lot of testimony about how this is sort of new and evolving technology and the standards that apply are catching up and there's best practices. You heard a lot about that today. So I don't think we can just say, well, if CODIS is fine, this is fine. It's not the same at all. There is a ton of information. It's your whole genome that gets profiled. Maybe the SNP that uploads into MyHeritage, which it shouldn't have, maybe that SNP doesn't tell you certain things about a health profile, but the potentiality is there in the SNP profile. For $12, you can upload that profile and find out all kinds of personal health information. It's the potentiality of that. And that's the Carpenter case that talked about the potentiality of that. People have an absolute privacy interest in their health matters. Idaho has a couple of different laws on the books. It has the family DNA law on the books. And think about HIPAA. I mean, we all have to sign those forms every time we go to the doctor if we want anything released to our surgeon.
Stick with the genealogy.
Matters are important.
The entire genealogy.
If you can upload one of these profiles for $12 and find out all kinds of information, how is that not a Fourth Amendment issue? That's what that SNP profile can do. And that was done twice without a warrant in this case. And there should have been a warrant. It violates Fourth Amendment rights, Article 1, Section 17 rights, and this must be suppressed.
Thank you.
She didn't give him a chance to ask anything. He was
All right,
he
the
was asking a
matter
lot of
will be,
questions.
Taken under advisement. Let's proceed with the Frank's argument on the IGG and the Frank's proffer.
That's getting denied.
Or did I get it wrong again?
Your Honor, I'm prepared to do that. I would request that the court maybe give me 5 minutes. I have
All right.
different things.
We'll take 5.
Thank you.
Back in 5.
Wow. Well, I mean, I missed some of it. So
Not much.
but
15 minutes.
I have to say, like my initial thoughts were just that, the argument that the policy represents an acknowledgement that the DNA database searches implicate privacy issues. I didn't hear the policy. I'm assuming that was sort of like implicit in her argument. Also, the judge brought up, when you share something with a third party, as the state mentioned, and the judge made a distinction. I can't remember what it was now off the top of my head, but another distinction is when you share it with a, contingency, like, but you cannot share this with the police. Now, I don't know if that's been something that's been taken up in the cell phone sort of arena before, but I don't think her analogy with the cell phone is too far off because they find a cell phone at the crime scene, they still need to get a warrant to do the extraction. So it is somewhat similar, although
We've had that debate that I don't find it to be all that similar. The difference being in what was interesting from the state was the concept of that they're using only the portion of DNA as to identification, thereby making the comparison to fingerprints. That they're not
exactly.
right. So, but I'm rejecting that. But just be clear. The law is currently situated right now. Brian Kohberger has zero standing to challenge that as having a privacy interest in a distant relative's DNA. Like
Now,
as the law
here's
is currently situated,
I would disagree if
really,
he's denying it's his DNA. If he's saying it's not his DNA, then it's that double-edged sword that the state was talking about. Can't both tell us it's not yours and you have standing in it. If it is his DNA and he admits that, which he'd have to admit in order to bring the motion, then I do think he has standing because it is in part his DNA. It's a family member's, but it's also his. Sort of like I
see,
mean,
but they're not trying to kick the DNA from the sheath. They're trying like the problem with this motion is it's misplaced because what she's really trying to do is get the whole case dismissed as everything being fruit of the poisonous tree because of the fact they used IgG to make the comparison and they found that it was his father in terms of the trash pull. And they said, okay, well, Brian, his son, who's not in CODIS, who has never given a profile anywhere, it's a match to him. So and based on that, that's what they got the arrest warrant on.
it just to
So
me makes zero sense why they would not have just done, she's like, all right, well, they've said STRs are fine, blah, 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 blah. Why wouldn't they just do a straight YSTR and compare the two YSTRs? Like, I don't understand why they would need to go through a whole IgG thing when it's just, when you're just comparing one person to one person. You're not trying to do a whole genealogy search. You're
no, I'm
literally,
not wrong, DB. What am I wrong about?
what are you jumping down people's throats for?
DB is like constantly on my ass. What am I wrong about, DB? I'm curious because that's exactly what happened in terms of how they got the warrant. They got the warrant because there was a genealogical match with his father. It was his father's profile. That is what they based the warrant on. Whether or not they're trying to, like, they're never going to get the sheath suppressed. The bigger issue is going to be they have Kohberger's DNA now. Like, to me, the IgG stuff is irrelevant. Now they can just say, okay, look, it's a match between the defendant, which we now have his profile, and the sheath. So, I mean, like the part of the arg. No, I'm not hangry, y'all.
You haven't eaten all day. That's true, though.
No, I did.
What? When?
I ate the rest of the gyros.
Oh, well, I just want to answer Susan's comment. That is an absolutely accurate statement that anyone who lives in the house can consent. Now, if your husband had a private room in the house that he kept secured and did not allow you in, that would be different.
Mm,
I mean, it would with a roommate. I've never seen the argument with a husband, like a spouse. But if you've got a certain room in a house shared with others that the other person has no access to, like a mother and son, I've made the argument and I've seen the argument. If he's got his own room, lock on the door.
yeah. What case was that where we had the lock on the
remember.
door?
But
they kept
even
all
if
their
like
shit
the
locked
mom's
up.
like, I never go in there. I was forbade from going in there and I never do go in there. Even without the lock on the door, that's not a common area. She doesn't have the authority to authorize anyone to go in it because she's not even allowed to go in it. She's allowed to go in it. She can authorize someone else to go in it.
All right.
But
So
going back to your original thing that you said about standing, if he is admitting it's his DNA, obviously it's not a black and white kind of argument. None of this is. This is sort of making new law, however you look at it. But I think technically he would have standing because by doing that, it got to his DNA. So uh, there's, there's your standing. Like, again, if you go into the house and it's shared and, Susan gave permission for the cops to go in, the husband surely has standing because it's also his house. So it's also in part his DNA, especially when you're talking about otherwise, obviously, they wouldn't have been able to connect the two if they didn't share DNA. It's novel, but I think it's what basically the crypto tax lawyer was saying, you know, do it, call it.
Well, but
It's
that's
case of first impression.
well, we know that. Like every IGG case is a case of first impression. I've been saying this for 2 years that this thing is going to go up to the Supreme Court because the issue has to be resolved by the US Supreme Court. So, and my argument is exactly that there's nothing like, we have nothing in terms of evidentiary items that exist in the world that even come close to DNA. DNA contains more information about us personally than anything on the planet. There's nothing even remotely close to it. And this ability to be able to use distant relatives in order, because it's a matter of, if I'm going to say, all right, look, if I'm law enforcement, I'm just going to go and kind of I've got a profile here that I developed from some evidence that I got at a crime scene. And I'm just going to go, just check to see if there's anybody that has that same strand out there. And it turns out that they find somebody. I mean, the fact that there's just no other type of evidence that exists that we share with other people. Like fingerprints is different. Like I don't have the same fingerprint
Right, as
as
someone else.
anybody else on the planet.
And that's why
Whereas
the judge was making the distinction, like, all right, well, was there someone in that database that had said that they didn't want to be searched that was searched? Because that also is gonna help with standing, whether it's not, even if you can extend it to him, if the police aren't supposed to be searching it, because then you're back at the issue of there was no right to privacy, um, as that person actually shared it, just like, if you share letting someone into a joint house. So the fact is that it sounds like they went backdoored it instead of following it. So I don't even know if the defense knows who the hell's DNA did they find anyway that connected them to him? Like, where's
it was his father's.
no, who's in the database? How did they do it? It's not magic. They had to find something and then do their whole, genetic
Well,
evaluation of it.
no, I think what happened is that, so they developed the profile from the sheath, from the touch DNA. on the
Right? We
sheath.
know that.
Okay, but when they went and got the trash and they did the trash pull,
Right.
now I've heard people say, well, and we talked about this last night. I don't know how they would know to specifically not be trying to get Brian's from the garbage. Like how would they know what had what on it? So I think that they took several items and then they shipped them off, overnighted them to the lab, and then
Right.
allegedly got it back in 24 hours.
Right.
It turns out that it's a profile. So like his
So then
father
where
had
the hell is
uploaded
this
it.
IG? That's what I keep asking. Where's the IgG
Well,
aspect
that's
of
what
it?
Ann Taylor keeps asking for. Is like, well, like those are that was what she was begging for. I need all the information about the IgG aspect of it that they're just not providing me. So
I still don't understand why they would need to do that when they had two people's
All right.
one person's DNA to
Let's
compare.
take up Frank's.
Your Honor, I think on the court's bench, there was a document placed, so
What?
Is it called?
it had initials to
Oh,
comply
thank
with
you.
the court's.
Appreciate it.
All right. Your Honor, the purpose we're here for today is to offer you a preliminary showing of why we should have a Frank's hearing. To do that, we will show you that in this circumstance, the affidavits that supported search warrants in this case had false information in them that was intentionally placed there. There was intentional omissions of information that are material and exculpatory to Mr. Kohberger. And without the false statements and with the added information in, probable cause on the warrants should not be found. Today, I'm asking you to listen to what we have to say, look at the exhibits that have been admitted, and I'll walk through those with you to talk about the 13 areas. And at the end of this hearing, we will have met the preliminary showing required in order to schedule a Frank's hearing and fully challenge this.
With the exception of the IGG, which I think we've already heard the evidence on. So
We did hear the evidence, Your Honor, and I will not repeat that evidence. I'll argue from that today.
my only point being that's not in the preliminary stage that all the other issues are on.
Okay. Well, I'll try to hit that as hard as I can then. Your Honor, in this case, there were a lot of search warrants. I'm going to draw the court's attention to those beginning on December 23rd. That day is important because it was just a few days prior to that, that for the first time ever, Brian Kohberger's name came up in the course of this investigation. Your Honor wouldn't know that by reading the affidavits for probable cause. Nobody would know that. That's because that information is omitted from the affidavit. That information is something that you heard about this morning in testimony, that but for the FBI's work going into databases they shouldn't have been going into, violating their own policy, keeping no records, and doing this all behind the scenes in secret, that's the only way a name was produced. Prior to that time, the lead detective in the case had not heard the name Brian Kohberger. He had not crossed their radar. That's nowhere in the affidavit, and that's important because that's intentionally withheld from the affidavit because of the work the FBI did, because the FBI went behind the scenes and did things that they shouldn't have been doing, because they searched databases that they shouldn't have been doing. We don't know what else they did wrong because everything else is a secret. We don't know what else they did wrong because there's no record kept. There's no process kept. We can't rebuild the process that they did to identify Mr. Kohberger. We can't do any of that because they kept no records, produced no records, and did this all behind closed doors, and it was withheld from the magistrate. Had the judge heard about that, signing probable cause, that would have been really important to understand. We don't know this name. We heard it for the first time now, and we only know it because we violated our own policy to find that. That may have given the judge caution. It may have made the judge wonder what else are they doing behind the scenes. But that was withheld from the judge. That judge never got to know that. Let's talk about what the judge did get to know with that in mind, and that's a really important backdrop. These affidavits are a group effort. I think the court's heard a little bit about that, and if the court has some of the initial exhibits, the court will know, and I'm at D2. The court will know that this was a group effort. The FBI, the same FBI that went behind and violated their own policy to try to identify somebody, they were co-located with Moscow Police Department and working on these affidavits to present to the judge. The first warrant that gets anything related to Mr. Kohberger is, I refer to it as AT&T 1. It's on 12/23/22, and it's for 48 hours worth of records of Mr. Kohberger. And I want to go through that warrant with the court having in mind that the IGG was purposefully and intentionally withheld from the magistrate. And I want to talk about some of the other problems with that warrant. This probable cause affidavit talks about an interview they had where the person that was interviewed said that she heard things and saw things within her house. But what is written in the probable cause affidavit is seriously lacking in detail. It's wrong and it's false in many places. The way the affidavit reads, it says this person stated she went to sleep on the second floor. She was awoken at 4 by what she stated sounded like one of the victims playing with the dog, which was on the 3rd floor. A short time later, she thought she heard one of the victims say something. That caveat, she thought she heard, is a problem. That's not at all what was said. This person was interviewed shortly after 911 was called in the afternoon of November 13th, 2022. And she was sure, I'm at Defendant's Exhibit 8A, page 281, lines 4 through 10, when this witness was sure that she heard this particular victim go up the stairs, and then come running back down the stairs. That is not what's contained in this affidavit at all. That is repeated during this same interview a couple of different times at page 287. It's also repeated in a subsequent interview that same day. This is Defendant's Exhibit 8B. That's at page 313 and again at 320. I've got one more of these where this is repeated.
Wow.
What?
It's repeated again in D8C.
But about her real
as well.
statements, the witness's real statements.
That is
Wow.
important because that's misleading to the judge. That waters down what was said, and that matters in the probable cause affidavit because the officers, when they wrote this, knew that wasn't the case. They knew this particular person that DM said was upright and running down the stairs, that's not what happened. That person was killed in the bed and never left the bed. And so the officers water that down because they know that fact is wrong, but they don't tell the magistrate that. They also don't tell the magistrate that this witness has claimed memory problems, that this witness has claimed that she's not sure what she heard or saw was real or whether it was at a dream, and that is contained in Defendant's
What?
8C, and that's going to be beginning at page 396, 398, 399, 403. There's further statements from that witness in that police interview that said that she had had too much to drink and couldn't remember. None of that is given to the magistrate. That is information that's withheld. That's credibility of the person telling law enforcement these things, and the magistrate
Credibility
had
doesn't
a
come into
right to
play.
know that whatever is laid out in here isn't exactly the way it was. That person had credibility issues, and she said things that were just absolutely untrue and couldn't have been true. Law enforcement knew that. That was intentionally withheld from the magistrate. That matters when we're talking about credibility and sets this whole thing into motion.
I'd be arguing it is true and it changes
Your
the
Honor,
whole
the next
timeline.
part of the affidavit talks about what they have determined to be suspect vehicle number 1. And it
Bushy
trails
eyebrows.
a path of pieced together cameras. But what they don't tell the magistrate is that the camera near the residence, the 1112 King Road camera near 1122 King Road, you can't tell what kind of car it is. They don't tell the magistrate that that's an impossible car, that their expert can't make an identification off that. They don't tell the magistrate that this is pieced together from various other videos throughout the area. That's withheld from the magistrate. That's important information when you tell a magistrate, we found this car doing this thing and we know what it is. It's around this particular area.
The judge's head is saying you're losing me.
The next issue is the year of the car. Law enforcement works with the FBI to determine the year of the car, and the FBI provides some possibilities after numerous submissions to them, and the court knows this and can read about this. This is going to be in D10. That's in D9. And finally, after several submissions, that's when the FBI IML says I can make a car identification. The issue with that that's not disclosed to the magistrate is that car appears one time on one video and not any of the others that they try to say are the path. It's not, let me see if I can say this right. It's not following a consistent trail where the one camera that can identify the car where it appears again. It appears one time, and then what law enforcement did was they took several videos from all over the area and said, well, it's the same car, and we have an identification. That's not all. The identification was most comfortably from that FBI agent to be a 2011 to 2013 Elantra. And that's what law enforcement relied on. The court has, it is D12, and it's the Be on the Lookout that was issued by Moscow Police Department, where they look for a 2011 to 13 Hyundai Elantra. And that's what they're looking for. And they don't tell the magistrate that's what they're looking for. They mislead the magistrate and let the magistrate believe that they have a clear view of this car making this loop. And that's just not what happened. It's pieced together and it doesn't make a whole lot of sense. Law enforcement in their affidavits talked about this dog barking, and they key some time. And they say this is when something was happening inside this house. We can hear this dog barking. And they use the videotape to get a time off that, the surveillance tape from the neighborhood, the 1112 King. And so they've got this time, but they also have this video, this trail that they've picked out a time that something probably happened here. And they don't tell the magistrate that this dog that's barking continues on long after the car they're interested in has left the area and then abruptly stops. Your Honor, the dog was found the next day inside the house in a bedroom with an open door, where the other bedrooms that contained people that died, their bedroom doors were open, and this dog had not tracked any blood around. The dog had no blood on it whatsoever, but it was just sitting in an open room a day later. The magistrate is not informed about that either. Then the police department goes through maneuvers to tell the magistrate that they did this investigation. They talk about a traffic stop, 2 traffic stops actually, and there's no connector in there. This is where the lack of the IGG becomes really important. If you know about the IGG, you know why that would be built. Otherwise, 2 random traffic stops months ago in pretty populated areas with a lot of college kids really doesn't add up to be an investigation. But those are put in there to try to bolster up this investigation and say it was something that it wasn't. Probably the worst part of that is relying on, after the BOLO went out for 2011 to 13 Elantra, then WSU, Washington State University officers find cars. They find one that's registered to Brian Kohberger, parked at the apartments he lived in, but it was a 2015 Elantra, and so they don't really do much with it. But this is placed, that is placed in the affidavit like it was an investigative fact, and it wasn't. It was on the 20th of December when the detective, the lead detective, got a hold of WSU police and found out about that and said, oh, hey, you called this in. He didn't know about that before, but there's no context around that. That's just stacked in there like it creates probable cause when it doesn't. You know that's the case when you look at a couple of our exhibits. One is prior testimony from that same detective. And if you look at the messaging between the detective and the WSU police officer about the timing of that. So it's based on this false investigation trail, and it's based on statements that are completely out of context from somebody that they interviewed that are incorrect statements when you take the totality of the circumstances together, and statements that this person disclaimed a couple of days later because she wasn't sure what she remembered was real, and give that to the judge. If you add in the missing piece of IGG and what happened with that, and as a judge, you know you've got law enforcement willing to violate their own policy, and you know that you're not being told the full story about what a witness is saying, and you're being led down this path to say there's a real investigation when there wasn't a real investigation, you don't find probable cause on that.
If I,
And then a car made a loop that it didn't
find
make.
that the IGG was not unconstitutionally obtained, doesn't it just add to the probable cause?
No.
If it were to have been disclosed, it would have simply created more basis to suspect Kohberger.
Your Honor, if it had been disclosed, think about how that would read. We used a process to make an identification. This is a new technology. This is called investigative genetic genealogy, and we identified somebody. We did not keep any of our documentation because even though Department of Justice policy says we need to, we decided not to. Even though it says we can't go into certain databases, we really wanted to figure out who this was, so we just ignored that policy altogether. I don't know how a judge could find that credible. You don't even know how that happened. There is a great big question mark about how that happened. To Your Honor's point, you should find it unconstitutional. If you don't find it unconstitutional, it's a separate analysis. I appreciated being able to talk to the witness about that today, but it's a completely separate analysis. You're looking at integrity. You're looking at what a court can rely on to sign off on an affidavit or a search warrant. If an affidavit is presented to a judge and you know that the rules don't matter, that terms of use of a database don't matter, and that you're going to hide what you do, and that doesn't matter either, there's not a lot to rely on. If law enforcement came to the magistrate and said, we want to go search this house over here, and they said, we really think there's going to be evidence of a crime in there because we've got this confidential informant, and this confidential informant has provided a lead, but we need to tell you that we don't have real reason to trust this confidential informant because they won't tell us how they know that. They gave us a picture, but they won't tell us where they got it from or when they got it or what means they used. They threw away their camera. They threw away all the metadata. They won't tell us anything about that. And by the way, the confidential informant maybe has some integrity issues. A judge is not going to sign off on that. And then if you say, but to support that, I built this false look at a whole investigation here. I'm going to tell you these other things that I know that I had no idea about before my confidential informant was here. And these things don't add up anyway. There is not, in my view, a judge that's going to find probable cause because somebody got stopped by law enforcement. I think it was a seatbelt ticket months before.
Purpose of the submission of that was simply to identify the car that he drove and the fact it didn't have a license plate on the front.
Yeah, but she just
It's
said that.
otherwise connected to the homicide, except to say this is a car of interest and the defendant was found driving it.
Well, let's talk about that license plate for a second, though, because that's not something you can see from the videos. And that was testimony you heard today. You can't see that from the video that the cops relied on here. So that bit about the license plate, that's something a little bit extra that happened after we have this IGG stuff. That wasn't known before. There was no video collected from WSU before. There was no communication with the officers at WSU before. So before the identification through IGG.
I'm just not tracking why that matters. But go ahead.
It matters because
There you go.
this wasn't a real investigation. These are things that are put in there to make it look like an investigation happened, to say, don't look here at this big glaring thing that's missing, this whole piece about why we identified him. Don't look here. We don't want you to look here because this is ugly, this is dirty, and this isn't real. That's precisely why those things are placed in that PC affidavit like that. So based on that, the first warrant gets issued. It doesn't end there. This warrant is not good. There's too much missing information, false information, and information withheld from the magistrate here. But then the warrants just rely on one another. There are other things to add into later warrants as well. And so I want to go through some of those other things with you. I do want to comment on the affidavits being used by a variety of officers. I understand the collective knowledge doctrine.
I mean,
but that's not
he's
what
saying a
was
lot
going
with his
on.
face.
You have an affidavit that
Is he?
sometimes Moscow police attribute it to
Just
the
doing
person
this.
that really wrote it, but quite often it's just the name taken off, and who claims to have done the work is whoever signed the bottom of it, and it can't be the same. So it's not quite the same thing, and that matters as well. But let's talk about the second warrant. The second warrant is also AT&T. The first one comes in, and an hour later, they say they have all this data analyzed, and they say they now need 6 months worth of phone records for Brian Kohberger's phone. They do acknowledge that his phone wasn't contained within
Checking
the
his watch
geofence,
now.
when they looked at the geofence. But this second warrant is important, and we're going to talk about minutes difference of time. In the first AT&T warrant, in that affidavit, the police officer talks about 2:42 a.m. that WSU cameras, because they start looking at WSU cameras after the IGG identification, they find a white car that they say is an Elantra at 2:42. So they get the phone records, and then it becomes 2:44 that they say Mr. Kohberger's leaving his residence, 2:44 a.m. And the place near Bishop Boulevard where one could turn to go to Moscow at 2:42 is inconsistent with 2:44, but they don't correct that. They don't correct that. They don't say that vehicle at 2:42 cannot have been the right white Elantra running around that night, because we now know it was at 2:44 a.m. They want to keep that in there because they want the car positioned like it's going to be going to Moscow. And that is really important with the misleading of the magistrate. When you look at 1A, that's the map we looked at earlier today, where there's the whole loop around, but there's a blue line as if pointing the car towards Moscow, and that's not what happened. They then report the phone stops reporting to the network at 2:47 a.m. And that's not right. we submitted their cell experts report that say the phone stops reporting at 2:54 a.m. We submitted 2 affidavits to you from our experts who have worked with the call detail records, and that's just not right. Don't get caught up in thinking 7 minutes don't matter here. We're talking about ground that can be covered in a vehicle in a short time. We're talking about 2 towns that are fairly close together. And so the way a car points when they go off a network matters a whole lot in this circumstance. That's not corrected in any of the affidavits. That's the part that's really exculpatory to Mr. Kohberger, is what direction, when the phone stops reporting to the network, what direction is the car traveling? And you can know that based on the cell towers, the handoffs from tower to tower as it tracks where a phone's going. The FBI knows how to do this. They chose not to do this. They chose to take a time 7 minutes before it really stopped reporting. And they chose to make a map that showed a direction that that phone wasn't traveling in, to create a false narrative for the magistrate to rely on to find
And he should be
probable
peeking
cause.
up for this, I think. Well, he's looking now at least.
Your Honor, I draw the court's attention to D7 and 8. Those are the affidavits from the defense experts. Their CVs are in D28. Once the second AT&T warrant comes, then you end up with warrants for Mr. Kohberger's arrest. You end up with warrants for DNA samples to be taken, warrants for the search of his apartment, the search of his car, the search of his parents' house. Those are the warrants that are next implied in that. Here, what's added to that set of affidavits is the paragraph that talks about Mr. Kohberger's phone using a tower that provides service to 1122 King on a number of occasions. The PC affidavit says 12. Your Honor needs to take a look at, I believe it is D1B and C. That's an email from Nicholas Balance, and he's talking to the detective in Moscow about the dates that he says this thing happens. And then he puts those dates in his cast draft report and in his cast final report, and they don't match up. There are different dates on those, different times on those. But the really big deal about that is that it's misleading when you say the cell tower that also services this particular location. Moscow has, I think, 2 cell towers that service the town. Those cover places that one shops, places that one eats, places that one gets gas in Moscow. From the records, you can see handoffs, and so you know where a vehicle is going. You can know whether it's stationary or not. You can know whether it's parked, looking at a particular place or not. Based on those records, we also provided the records just so the court would know there's a volume of records. I don't expect the court to decipher those records. But based on those records, they absolutely knew that Mr. Kohberger wasn't around that residence, wasn't parked near the residence, didn't stop and have his phone in a stationary position at that residence. They absolutely knew that that's not what was happening, but they put it in there to make a connection that didn't exist. They put it in there so that the judge would think that this was the right person, and they shouldn't have done that. They knew that was incorrect. They also changed that quite a bit, performed a drive testing, and so there were other bits of data that kept coming in so that they would know that was untrue. Now, for a magistrate to be relying, remember, on somebody who's a witness, somebody who's been interviewed 4 or 5 times, and continually says something that's absolutely impossible, has memory problems, and the judge never knows that, and we'll keep the IGG identification off to the side. But then you have this false narrative that looks like stalking, that looks like following, and it's not true. That is extremely damaging. It's very misleading. It's an outright lie to the magistrate. When you omit that kind of information, when you take that context out, you might as well say stalking because that's what you're trying to say, and you know that's not true. This court can rely on our proffer in D1B and in the CAST draft report and in the CAST final report because those dates change. The court can rely on the evidence that will be produced at a hearing from defense experts that will talk about the handoffs, the patterns of handoffs, and how misleading that paragraph was to the magistrate. The real story is exculpatory to Mr. Kohberger. He was not stationary around that house. He was never at that house. He did go to Moscow. He did drive around, but he wasn't over there. And the phone records absolutely show that. We'll move forward to the set of warrants that come a little bit later in February, March, April. I'm talking about Amazon, Google, Apple, those kinds of warrants that come later. Here's what is left out of all of those warrants. The fact that Mr. Kohberger gets arrested, his apartment gets searched, his car gets searched, his car gets searched again, and his car gets searched again, and there's absolutely no connection between him and anybody from 1122 King. And what I mean by that is that there's no blood in his car. There's no he wasn't connected to that house, to the people in the house. Your Honor, I'm
Maybe I mistake me thinking of a different date for the AT&T. I thought, not the cell tower stuff. Are you still talking about the cell tower stuff?
No, I mean, that stuff applies to every single warrant we have because that was
I thought you
early.
transitioned to warrants that were obtained after the arrest.
I did.
Yeah, and by the time of the arrest, they had a direct DNA connection.
Your Honor, what I'm talking about,
Some other evidence that the defense can claim in cross-examination or their own case is exculpatory, but isn't the DNA connection in and of itself probable cause to support any of it from there?
Your Honor, the DNA I'm talking about is the lack of DNA in Mr. Kohberger's car and the lack of DNA in his apartment, the lack of connection to the individuals.
What is that? Even if disclosed, preclude a finding of probable cause when there's a DNA match between the DNA in the sheath and Mr. Kohberger. Isn't that probable cause every day and twice on Sunday?
Not in this context.
Twice on
Not in
Sunday.
this context, because of the IGG work. Because I mean, that's the ultimate question that will be before a jury. What does that mean, right? What does a knife sheath at a scene mean? That's
It
gonna be
means
the ultimate
probable
question.
cause.
Killed by a knife, that probably means a lot.
It might mean a lot.
Probable cause is not a
Right.
proof beyond a reasonable doubt standard. It's probable cause to think that this person might have done it.
Might.
And I'm not sure how that direct DNA connection to a sheath found on or near one of the victims doesn't close the book on anything on probable cause after that.
Closes it twice on
Well, I think
Sunday.
it doesn't close the door on probable cause. I think when you know the other factual information that the magistrate should have known I think
should
that
just be
there-
arguing they wouldn't have
there's a lot
gotten
of
there.
cause, even at a probable cause level, Judge. This was information withheld from the magistrate, and I'm talking about, let's just go with the car. Let's just go with,
I understand the lack of evidence of DNA material or other victim-related material in the car and in his apartment as asserted, but I'm not sure how that precludes
Overcomes.
probable cause when there's a
Right.
DNA match.
It's-
There's plenty of reasons that that might be the case. When a magistrate's looking at this, they have a direct DNA match to a person from a object associated, likely associated with a murder weapon. I have not yet a magistrate would not find that probable cause.
Yep.
if the magistrate had the other facts, I think the magistrate would have some serious concerns and would
Nope.
not find
No, they
probable
wouldn't.
cause. Your
I don't
Honor,
know why
the-
she's not arguing fruit of the
vehicle,
poisonous tree,
and I know the court knows what I'm going to say.
whether it's right or
There's
wrong.
not DNA in that vehicle that was brought out from a crime scene. This absolutely matters, Your Honor. If you want to go to the state's
Argue the
theory,
lack of DNA.
right, with their
for
videos that
probable
they've
cause.
talked about,
Come on.
they
Come
told the
on.
magistrate about that
Do
this is the
better.
video, this is what matters. It parks at this certain time, it leaves at this certain time. If you want to go to that, there's about 13 minutes of time, right? 13 minutes between the last time you see the car and the next time you see the car on the video. And if you end up with a car that's searched, and I mean searched and taken apart, the brake is taken apart, the gear shift is taken apart, the key fob is checked.
Sounds like doubt,
There's
not
no blood
probable.
on
Right.
any of that.
It's not
None.
probable cause.
The
It's
steering wheel.
none of this
There's
shit matters
some
for
kind of
this.
spray all over the interior
She's not
of
getting
the
a
car
hearing.
to check for it. There's no blood. I think that there's context that the magistrate should have known that's absolutely exculpatory to Mr. Kohberger, and it matters a whole lot.
At trial,
I'm not saying it's not potentially exculpatory. I'm just saying I'm not sure how knowing that in light
Changes
of a positive
probable cause.
DNA connection would trump, would cause any magistrate to say, well, okay, I guess there's no probable cause here because you couldn't find other connection to forensic evidence. When there are other things in the affidavit or affidavits at that point that could explain that, including the use of covering clothing and covering gloves and all that could be put into a bag real quick on the way out that was in one of the affidavits. I guess, and I don't intend to argue with you about it. I mean, I understand your other arguments, but when you get to once they have the actual DNA, evidentiary DNA, it seems to me that it's an uphill battle to say there's not probable cause.
She needs to recognize that and move on. She's going
Right.
to lose
Well, Your Honor, you
credibility.
should never get to that question, but I'm going to answer it for you. But you should never get to that question because
There,
you
that's
should have
all-
already found
That's
that
true.
AT&T 1 and AT&T 2 were terrible, and there's no probable cause for those, and they just build on each other. So you should find that the very first one lacked probable cause, and then everything else does as well. But let me answer your question there. If the magistrate judge had been told there's unknown male B in blood in the house attached to the handrail, that might have made more of a difference to her. Maybe a sheath that can be carried to the house and blood in the house that's not the same, maybe that matters. And then maybe the car being completely empty of any blood DNA connection, maybe that matters a little bit more. Maybe
Well, I'm just not sure why it matters for probable cause, but I think we're talking over each other, so I'll let you just go on.
Just take your cues and stick with what matters.
I don't think probable cause is in a vacuum. I think probable cause isn't one thing. I hope it's not one thing. I hope there has to be a little bit more than one thing, especially when you've got another thing that's the same as the one thing.
Well, I said I wouldn't do this, but I'm going to do it anyway because you brought up blood DNA of an unknown individual that was found, I think, on the handrail.
Yes.
Party house.
Doesn't that necessarily not exclude Mr. Kohberg? What it may do is suggest there might be a potential other person in addition involved if you assume that that blood was related to the victims and not some earlier event in the house.
If what the court is saying is exactly why the magistrate needed to know that. Is there another explanation here? I've got this sheath, but there are all these other things that if I know about them matter. What's the other explanation? What's going on with this investigation? What's happening here? That's exactly the point, Your Honor. What other explanation is there? The magistrate wasn't given a chance to
Not
ask
one that
that.
defies probable
She
cause.
wasn't given a chance to ask that when she wasn't told about unknown male B, blood on the handrail. She wasn't given a chance to ask about that when she wasn't told about unknown male D, blood on a glove right outside the residence. She wasn't
That's
given a chance
pretty
to ask any
compelling.
of those questions.
But
She didn't know that
probable cause.
Brian's car and the court's question, good question. What does that mean? Could it mean there's more than one person? The answer to that is, or it could mean it's not Brian because his car's got nothing in it and there were only 13 minutes to do this.
But it still
The
means it
magistrate
might
didn't get to know that.
be Brian.
DNA is still
Probable
on the
cause.
knife sheet, though. That's the problem, counsel.
Right.
For probable cause purposes.
If that's the
Move.
only thing she's told, I can see why she'd find probable cause. It's these other things that are withheld that create a context around it. I think the purpose of Frank's is to ask this very question, and this is a question. What do we want to do with our criminal justice system? Do we want to have one thing with no context around it when there's this other context that really matters?
Applying the Frank standard, which is even if you add that stuff, does that take away probable cause, counsel?
Right.
My problem is once you have a direct DNA tie to the defendant, for purposes of probable cause,
Right.
isn't for purposes of conviction, for purposes of probable cause, you have not explained to me why a reasonable magistrate, let alone any magistrate, wouldn't find probable cause there, even if they knew all those other facts. As to Mr. Kohberger, now, there may be, as
Not
you
that
say,
much,
other people
CH.
that
We can talk about it later.
creates concern or issues about that need to be investigated further. But I'm not sure that that diminishes the probable causes to Mr. Kohberger if his DNA is found on a knife sheath found on or near the victim who was stabbed with said alleged knife that would have been in said alleged sheath.
I think the most prominent question is how did that sheath get there? And I think when you ask that
That's
question,
one for
I think you can have
trial.
DNA on an object at a scene when you know about all of these other things and you don't find probable cause because there are more questions than there are answers. And all of a sudden, this one thing doesn't look as big. It doesn't look as everything pointing to it when you have the context around it. The magistrate didn't have to have every detail of the case, but knowing how many attempts to find a DNA connection there were, and it didn't exist in Brian's car, in Brian's apartment, that there's no other DNA in there other than an unknown male B that we know of for sure, an unknown male D outside. There is a lot of context there. And all of a sudden, this one thing, the question of how is that there is the question that the magistrate should have had. And then we come to all of the other things that we've talked about. We've come to what we relied on. One of the witnesses saying things that absolutely couldn't be true.
My God, this is reminding me of Sarah
One of the
Carver.
things that the witness who said these things that couldn't be true also admitted
Were
she didn't
were
really know
true and
anything.
point to something
You can't
different.
rely on that anymore, so you take that out. You know the identification to this sheath that maybe seems like it would be really good. You don't really even know how that happened, and you don't know how it got there. This isn't like
And B.
DNA in blood on the
What about
wall from
B?
Mr. Kohberger. That's not there. That doesn't exist in this scene. You're talking about an item that the question of how should be, especially when you know about the other male DNA in the house, and especially when you know about the lack of DNA connections. There's also no connection between the people in the house and Mr. Kohberger based on their cell phones, based on social media accounts. There's just no connection. The magistrate wasn't aware of all of those factors when she was being asked to decide on probable cause. I don't think criminal justice means one piece of evidence out of the context of everything else is all you need. Context matters a whole lot.
Well, you're not suggesting the magistrate was told that there was DNA evidence found in Mr. Kohberger's car or in his apartment. The lack of inclusion also can be viewed as the implied of, they're obviously not telling me they found this when they would have if they did.
Yep.
I'm not 100% sure I followed.
Really?
I'm not sure.
I mean,
Are
if the
you
judge
asking
doesn't know
why
they
I think
looked.
That's important as far as the Frank's purposes.
He's saying if they had it, they would have put it in there. So
You
That assumes they know they
implying, I
looked.
think,
Correct.
necessarily that the police intentionally didn't tell the magistrate that they didn't find the lack of evidence in other places, the apartment, the car, etc. Right?
Yes, that's right.
They didn't tell the magistrate that there was evidence. This is a omission.
This is one of the omissions. Yes. Yes, we have false statements and we have omissions both. It's not one thing in this case.
Yeah, he gets that. She's a little condescending.
Yeah. Thank you for that. I wasn't following the question the court was asking.
I did.
so did I.
I think the other
She's
thing,
she's losing it because she can see where his mind's
I think
going.
I covered all.
She
of
knows
my
she's
problems,
done.
Your Honor, thank you.
If I'm the state, I
Ask
don't even,
if he's got other questions. I love this back and forth he does.
yeah, it's
Shows
like
you
an
what he's thinking, tells you where you
appellate-
gotta.
it's like
Now,
an appellate
were you going
judge.
to address the IGG Franks issue, or is Ms. Jennings going to cover all of it?
Your Honor, I think I'm going to cover all of it.
All right, go ahead.
Going to attempt to.
I don't think you have to do shit. The judge said it. The sheath is enough.
Yeah, but you got to get there. He seems like he's at least contemplating her other arguments. There was some
I don't
stuff
think
there.
he is. I don't think he is. I think if you stripped it all away, consider it all to be lies,
Well aware.
that
You have to
that
make
sheath
two
is enough.
separate
But you don't have that in the beginning, babe. You don't have that on all the first things she was saying.
First, you have to
For the
decide
warrants?
today.
Right. Not yet.
Has the defendant made a substantial, not just a preliminary showing, but a substantial preliminary showing that the affidavits, and in our case, we're referring to the Exhibit A's that were attached to each of the affidavits for probable cause, that they were the basis, which were the basis for multiple search warrant applications, that within those Exhibit A's, there were deliberate or recklessly false statements or omissions. This is a high burden, and this is a very high hurdle for them to jump over. Now, if you can answer yes to that, then and only then should we move on. And then ask the second question, does that even matter? Does that statement actually diminish the probable cause finding? It's only when the answer to both of those questions is yes, should you then even consider granting a Franks hearing. The motion for a Franks hearing is a serious allegation. The allegation is that law enforcement acted improperly, that they lied to the magistrate in order to secure the warrant. The statements have to be deliberate, reckless, false. That's the standard. Franks is not implicated by just simple mistakes or misunderstandings about the evidence or Scrivener's errors or even just negligence. As the court is well aware, this is serious. The defendant is alleging law enforcement lied to secure
they
the
did.
probable cause in this case. And the state submits the defendant has failed to back up this claim. And they failed because they can't. law enforcement
I heard at least
submitted
2
probable
lies.
cause affidavits to the magistrate based on the information they had available to them at the time that the various applications were made. That's how it's supposed to work, and that's how it worked. The defendant has alleged 13 separate areas where they say there's a Franks violation. I'm going to go through those so that I make sure that I get through each of them in the same order that defendant addressed them in their motion and as the state addressed them in our response. And that starts with this idea of attacking Exhibit A. As the court knows, in Latah County, it's our practice, we submit an affidavit for probable cause. As I said, attached to that affidavit is what we call an Exhibit A. That Exhibit A is law enforcement officers' statements, laying out all the various facts known to them related to probable cause in order to support the issuance of a search warrant. In this case, Exhibit A, by the time we get to where we're challenging, was about 20 pages of facts for the magistrate to review. Essentially, the same Exhibit A was relied upon for the application of multiple warrants. This was a massive investigation. You heard testimony earlier today from Detective Payne. Multiple officers were involved in this investigation from multiple agencies. And they were doing briefings. For weeks at a time, they received 2 briefings a day with all the lead investigators in the same room receiving the same information. This information was then put into this Exhibit A for the basis of a probable cause affidavit for search warrants. A working document like this, with the most up-to-date information, was the best way to ensure the magistrate was getting the most complete and accurate information. And defendant wants to take issue with this process. But
What do I do if the affidavit is attached to Detective A's submission, is Detective A's affidavit, right? And there's for purposes of my question, a material
Misrepresentation.
reckless statement in there.
Just say it.
But
Lie.
Detective A isn't the one that made it. It was another person on the team, let's say the cast member expert.
well,
How does that affect the Franks analysis as it relates to the
It doesn't, I
affidavit
don't
submitted
think.
by Detective A?
If Detective B deliberately gave Detective A false
would say
information,
Detective A would have
she should be taking notes right here.
to
I don't know if she is.
that was a materially reckless statement made by
That's your fucking job.
Even if the person that made the statement on the team knows that that statement going into the affidavit, the group affidavit, if you will, or the group statement is going to ultimately make its way to the magistrate?
Don't even try it.
I'll
Don't
concede,
even-
I think there's an issue there,
Yes, thank you. Woo.
but that's not what happened.
Or is it?
I don't think that any officer can submit a statement that they know is going to go in front of a magistrate and do so
That's
recklessly.
what the defense attorney should have said when he said, well, once we get the
And if
direct
they do
connection.
so, then I agree. That has to, the court should take issue with that.
Can't argue otherwise.
But the cooperative nature of this investigation and this kind of group effort is allowed.
Not if one's lying to the one
As
hand's lying to
discussed
the
more
other.
extensively in the state's response, we have several Idaho
Lying
cases that
hands.
support this. State v. Rubio, State v. Gomez, State v. Alger. And in our case, the probable cause affidavit, it wasn't as if the judge wasn't put on notice that this was exactly what was happening. The judge was put on notice. Each affidavit explicitly told the magistrate, blank officer, depending on who was applying for it, quote, is being assisted by members of the Idaho State Police and agents of the Federal Bureau of Investigations. Throughout the document, it makes references. I consulted with FBI Vehicle Specialist S.A. Imel. I consulted with FBI SA Balance regarding CAST. I consulted with FBI SA Hill regarding surveillance footage. It's very clear what the sources of the information were coming from. It could absolutely be reasonably inferred where the information was coming from. The magistrate was not at all misled regarding the sources of each of all the information.
Damn it. Couldn't find the Are You Sure?
I'm going to talk a little bit about this idea that there's some issue with who did the work. In reference to Google. They claim that the CSLI work alleges Kohberger around the King Road residence.
Bukkake?
And this same claim is in Exhibit A signed by Detective Blaker. Well, this is inaccurate. The officer signing the affidavit did not claim to do the CAST work.
Did you mean AT&T?
Yes. They didn't claim to have gotten those records.
He knows the facts.
And put them in to their program to determine the approximate locations of the phone. That was done by Special Agent Balance.
Who
And
apparently
the affidavit
lied.
makes that clear. And defendant ignores the entire paragraph within Exhibit A that makes that clear. Quote, I consulted with an FBI special agent that's a certified member of CAST. This paragraph goes on to explain what CAST is, what CAST does, the experience
the one that
that's
said,
involved, SA Balance's own
We
experience.
show him at spot
And
B,
then
but we know
the
he wasn't there.
Law enforcement officer then states, from information provided by CAST, I was able to determine estimated locations for the 8458 phone. That's not claiming to have done the CSLI work, but instead is just a reflection. The work was done by Balance. Investigators reviewed that and then made some determinations of the approximate locations for that 8458 phone. And we're going to get into this in a little bit down because this comes up again. All about the cell phone. And we're just going to take we have two different opinions about what those records show. We have an expert who tells us, and that's what was relayed in the probable cause affidavit. And those opinions haven't changed.
True, Vicky.
We differ on a few factual
He's sitting up a
issues.
little more.
I believe there are 3 towers that provide service to the Moscow area. Defendant is cool.
Here's my concern with you telling me that at this stage of things.
Mm.
Where in the record is that currently? Apart from anything you may have submitted after they filed their Frank's motion.
What specifically?
That there are 3 towers.
I
Mm.
believe I referenced it in my response.
Well, yeah, but that doesn't. If you give me evidence and I rely on that evidence, then I have to give them a full Frank's hearing. And so that's why.
Oh, that's
very clear to
interesting.
say I'm looking at what the proffer is from the defense
I didn't know that.
without evidence submitted by the state.
So don't
to
tell me
determine
something I don't
whether
know.
They have met their threshold burden. And so
Mm.
I get concerned when you start telling me things that are
Wow.
not necessarily part of the evidence.
Understood. We can
Disregard
move past
that.
the number of towers. Here's what is in evidence.
Your Honor,
though.
just kidding. Skidding.
And based off of the PC affidavit, is that the phone was in the area for the tower that provides service to the 1122 residence. Still maintain that's true.
Hmm?
Regardless, none of this has any bearing on the validity of the search warrant. Their argument is merely a clarification about which member did what work.
That's not their argument.
And
Is
that
it?
doesn't matter to the ultimate determination for probable cause. Defendant then makes some allegations regarding an eyewitness statements related to DM.
Yes, she
There's
did.
kind of two buckets of
Buckets.
evidence here.
She's doing the bucket thing.
The first bucket is that the defendant claims the magistrate was never informed that DM told law enforcement she, when
Absolutely.
shown a picture, didn't recognize the defendant.
That sounds exculpatory.
Well,
But she only saw his eyebrows. Did she recognize his eyebrows?
it's clear from
Did you see
reading
his
the probable
bushy ass
cause
eyebrows?
affidavit that she's not going
To recognize his
Wait.
caterpillar.
the
Sorry.
defendant.
What relevance was the statements of DM that were included in the affidavit as to probable cause?
Bushy
I
eyebrows.
cited those in my response throughout. She was,
What were they?
okay.
Bushy eyebrows.
I can tell you generally.
Frozen
the
shock
defendant
phase.
gave the same set of facts.
I understand the things that she said. Why was it important the magistrate know those things?
How did it contribute to the probable cause?
In other words, are they going to who the ID of the perpetrator is? Are they going to establish a timeline of when the alleged or when the murders took place? Okay, so it's part ID as well?
I think that it goes to giving a general description of the person that she saw in the residence around the time that corroborates when we know these crimes occurred.
So then
Yes, a
how's it
general
not
description
important she doesn't
is
recognize it?
material and relevant.
Get in front of the mic,
And that
counselor.
and that general description, which is what was provided in the PC affidavit, was consistent throughout all of her interviews. She described seeing someone wearing all black, a mask with only a portion of their face showing and visible. This person was male, white. She heard a voice that was not something that she recognized. The person was a slim, skinny, lean build. And the person was taller than she is around 5'8".
They did write this
That's
once they
what's
knew what he looked like.
important. It was that general description.
Not relevant for this, but you know.
And that general description did not change.
Is it also important to establish the timeline?
It is. It's important to establish the timeline to know when that the timeline matched the vehicle surveillance of when a suspect vehicle is coming into the area of 1122 and then leaves, as well as text communications of her relaying what she's observing during the same time period. And even if the state's wrong, that somehow there was some exculpatory relevance to some of her statements not being included in the probable cause affidavit.
For completely different
You
reasons
can
than the
take all
defense
of it
argued.
out, and the magistrate would still have probable cause. The second issue, defendant, the second kind of bucket that they
Is
take
credibility.
issue with DM
Buckets.
is about these other just statements that she gives during her interviews.
I was shit-faced.
The defendant argues when an eyewitness states she's not sure anything she saw was real, a magistrate should know about it. Well, the simple answer is investigators knew what she saw was real. And we know it wasn't a dream because they found the evidence discovered the next morning. Those statements didn't need to be included in the PC affidavit because they weren't exculpatory. They didn't support this idea that this didn't really happen, that somehow we got it wrong.
What is the this? She better describe what the this is.
The murders.
Well, but that's not what she saw anyway. So
Next,
Well, she's
defendant
saying the fact that there
attacks
were
the vehicle
4 dead kids
identification.
there.
no,
demonstrates- yes.
Well, this picture they're painting about how this happened just is simply not true. The magistrate was given a very detailed picture of the investigation at the time related to the white sedan, which was later determined to be
I'd like to hear about this because what she
This is
said
about
was,
5 pages of the probable cause affidavit.
look at him. He is doing the same
The
thing. He's like
reality is, yeah,
rubbing his
still
eyes.
images
Yeah.
and video were provided to a vehicle specialist. Based on his review, he provided information to investigators that the suspect vehicle was likely a Hyundai Elantra. There was some discussion regarding what was the most appropriate year range, but at the specialist direction, he said that the year range to be focused on was 2011 to 2016. So Detective Payne reasonably relied on his expertise as a vehicle specialist and included that in his probable cause affidavit. And the court has in front of it the emails attached as exhibits that show that's exactly what occurred. And the defendant appears to argue that, well, the vehicle specialist shouldn't have relied on this video because they can't tell that that was a Hyundai Elantra. To them, it doesn't look like, I guess, a Hyundai Elantra. And the video that is clear, well, they take issue with that video because, and specifically, we're talking about 1125 Ridge Road, because they say, well, that can't be surveillance video of the white Elantra, even though it was caught on video about 0.3 miles from the crime scene, about 3 minutes right before when we see the suspect vehicle enter the area of the crime scene, which 0.3 and 3 minutes appear to be the amount of time it would take
Sure, they
the
know what
vehicle
kind of
to
car it was,
travel
though.
to the area of the crime scene. They say, well, that can't be the right video because if it were, then the surveillance right up the street would have also caught this video. But we know that's not true. And that's been submitted to this court. Excuse me?
When was it submitted? to
Right.
this court?
What?
Well,
Show-
it was submitted through my response.
I was afraid that you were going to say.
Oh boy, you're giving him more evidence
It was
that's not in
submitted through my
evidence.
response
You're
that
giving her a
could-
hearing.
that their logic is flawed. And I can tell you, it has since been confirmed.
You're telling him
I
more
do not
evidence that's not in
have,
evidence.
and it has been discovered to defense.
You're telling him evidence that's not in
We've
evidence.
Had Special Agent Hill confirm,
Jesus,
and
come on.
he discovered this as
He
Bates
told you this
15990,
already.
which confirms that the
That's why he's rubbing his head right now.
surveillance camera that was set up to capture motion would not have captured the corner
She sure is.
the defendant says must have been necessarily captured. Again,
remember when I told you
It doesn't
don't
matter. At the end
offer
of the
evidence?
day, the defendant's speculation about the route of travel and their differing opinion on
Yes,
it isn't the
CH.
basis for a Franks hearing. There's no legal basis for second guessing a vehicle specialist's opinion. And they haven't
did
made a
chuckle.
substantial or a sufficient proffer for you to do that. Next, the briefing addresses the IgG issue. And
Is it possible to tell from the affidavit what shots and what cameras were relied upon to make the identification?
I know that the app, well, I don't know that you needed to. I don't know that all of that information had to be included.
That wasn't my question. My question is whether
I think this judge is better than everyone thinks.
the affidavit.
I think he's a good judge. I don't think. I think he makes that face in front of every
All right,
lawyer.
all right, wait,
in front of him.
stop.
It discusses that several surveillance videos were reviewed, that images were turned over to a vehicle specialist, and then that specialist made a determination. But no, we didn't walk through describing each and every still image or video to the magistrate.
They made it seem like that was a
Or did
loop,
we need to?
the same car.
Really, the IgG has been discussed extensively. I think the only real Frank's issue is, should the IgG process, the fact that it was not included in the PC, is that the basis for a Frank's hearing? But you heard testimony today that law enforcement received this tip and they made a strategic decision not to include it. They were told it's only a tip and that they should develop probable cause separately. And that's
magical
what they
tip?
did.
The magical tip?
And at the end of the day, Your Honor has already kind of hit the nail on the head through your questioning of Ms. Taylor. At the end of the day, this information regarding IgG
Thanks,
and
Afton.
use of IgG is only inculpatory. And the non-reliance on the IgG information does not diminish probable cause. And the IgG information was confirmed through the STR testing. I can't wrap my head around any argument that IgG and STR testing would be exculpatory.
Hmm?
Defendant makes kind of hay about the dog barking. And that I guess the magistrate should have been informed that a dog barked for 25 to 30 minutes.
Well, they did make it seem like the dog only barked during that
and this
time.
is just a reach for me. I'm still unclear how this is exculpatory.
But the dog could have been
And
continuing to bark
Again, this
because
fact just
its owner is dead.
does not diminish. Take out all information related to the dog. It doesn't diminish probable cause. Circling back to the cell phones, at the end of the day, this is the proffer is their opinion of the evidence. That's not the basis for a Frank's hearing. We're relying on our expert's opinion. They disagree. And that is a dispute that should be had, and it should be had at trial. And I suspect it will. But it doesn't give you the basis to grant a Frank's hearing.
You presenting evidence does.
Defendant the next area is the footprint. There was a footprint found outside of DM's bedroom. They claim that the inclusion of this was misleading. But again, there's nothing misleading about the statement. The statement says during the process of the crime scene, the investigators found a latent shoe print It was located during the second processing. It came back using a presumptive blood test and showed the presence of cellular material. They let the judge know that it was outside the door to DM's bedroom located on the second floor, and it's consistent with her statements. Yeah. Investigators provided the magistrate the information they had at the time of the investigation. Defendant's opinions about where the shoe print should have been located and it couldn't necessarily have been located there. Again, that just doesn't rise to the level to warrant a Franks hearing. Again, our case doesn't hinge on the identification of this shoe print. Neither did the PC affidavit. There was sufficient probable cause with or without this information. I'm going to address grand jury subpoenas. They didn't discuss it today, but it's addressed in their
Oh, boy.
motion.
Yes, before you get to that, can you address the allegation that the cell phone data was, I guess,
Misreported.
purposefully erroneous as to the time that the phone was no longer reporting?
And direction
Which
of
then
travel.
relates to the supposed
Direction of travel.
position of travel.
Right.
Thank you.
Well, I don't know that I completely wrap my head around the defendant's logic in this.
I have to, so help me out.
Well, I still don't
I
understand.
understand her statement and her argument. I'm trying to understand your response.
There you go.
I guess what was reported was the information known at the time that the probable cause affidavit was given.
By
There's-
Detective Payne? Or by a
Correct, the
cast member?
information that he was given from.
This goes to my
SMS.
first question about imputed erroneous statements.
She conceded it.
So I understand the allegation in that regard, not necessarily to be that Detective Payne knew the statement was wrong, because I'm not sure there's evidence of that. But did the cast specialist know that there was a misinterpretation or an erroneous report?
I don't think that you have before you a sufficient proffer that proves that the cast specialist.
judge thinks so.
Submitted false information. Apparently, there's a difference in the handoffs of 7 minutes. At the end of the day,
And the change is direction of travel.
no, I don't think it's incredibly material.
Is it material if you look at it in terms of where the phone was in that 7 minutes?
Right.
Well, it's material.
Going a direction different than what your affidavit says it was going, isn't that material?
The
Yes.
direction of travel, like, yes, I would say it was if it was found outside of Pullman. It was not. It was reporting to a tower in Pullman. This assumption assumes that cars can't change direction of travel.
Well, if they're going to someplace different, they do, counselor.
Assuming that then the same cell phone, which was then turned off, isn't
Didn't
then
turn around then?
also tied to the evidence where we do have information to believe a white sedan tied to Mr. Kohberger is then found on surveillance. We're not
No.
talking about 7 minutes. We're talking about 7 minutes at 2:50 in the morning which is about an hour, approximately a little over an hour.
Are you
before the
sure?
crime scene.
Are you
I don't follow the logic that this 7 minutes, an hour and 10 minutes prior proves that there's no way the defendant couldn't have traveled the 7 miles to Moscow, whether or not the car was pointed in a different direction or not.
But you told the magistrate he was pointing in the right direction.
It's a leap for me.
Look at him.
Does that answer?
He does that shit all the time.
Wait a
Like he
second.
did it for
wait,
both.
shh.
It's your answer, so.
You shush.
No,
Quit shushing me.
I was just, the
Let's
judge
say
was
it
about to
was.
talk.
Let's say that it was exculpatory. Let's say it was materially that it was false. It was recklessly included. It wasn't, but let's say it was.
Okay. And
Well, you still, the magistrate still had enough information before her to grant probable cause for the arrest.
for the warrants.
So we still don't get to a
Search
Frank's
warrants.
hearing, even if you want to make that leap. I can quickly go through grand jury subpoenas. At the end of the day, their desire still, this has come up several times throughout this process, their desire to see the actual grand jury subpoenas is not the basis for a Frank's hearing. There's just simply no legal basis to support that idea. And there is nothing obtained that was obtained in violation of any of the defendant's constitutional rights. They say they needed to know the scope, but it is not clear to the state how that would have made any difference in the probable cause determination or why the magistrate would need to know that. Again, this just appears to be another attempt by the defendant to try to obtain these federal grand jury subpoenas. And I submit to you, Frank's is not the proper avenue. We're going to go to lack of connection. I think this has already been addressed by Your Honor. At the end of the day, this fact just has no bearing on the probable cause determination. The investigators relayed the known information they had at the time, and timing is important. At the time of the application of most of the warrants, the evidence taken from the defendant and his vehicle was still being reviewed. We didn't know if there was a connection. Only a few warrants even fell outside of that. Apple, YouTube, Instagram, TikTok, PayPal, and Microsoft.
I thought AT&T.
However, even for those warrants, the state submits to you that fact's not necessarily exculpatory. The defendant's belongings and the vehicle were recovered approximately 6 weeks after the homicides. And that fact was known in the probable cause affidavit. It could be reasonably inferred. But to the extent the court believes that law enforcement should have included this information, again, I can accept that, but it's not enough to outweigh the balance of the information that was included that did establish probable cause. I submit to you the defendant has wholly failed to establish a single false statement or omission without which the magistrate would not have found probable cause.
I see
I ask that
Three.
you deny their motion for a Frank's hearing.
3.
Thank you.
I see 3. The fact that she said somebody was awake and walking up and down after at a certain time, the car doing the loop, and the direction of travel with and the time the cell phones went
I
off.
did my part to make you, so that you can and avoid asking questions unless I'm truly stumped.
Before I get started.
Pick up on what
I
he
want to
put
tell
down,
you
please.
In response to what the state said and then my summary. I'm curious about the new police report that was talked about. I didn't see it in the submission given to Your Honor.
I've had such an avalanche, I can't think of what it is off my head. If it did, it certainly wouldn't be part of the analysis for the court in determining whether or not you've met your showing to have a Frank's hearing.
Right, because She can't do that.
Well, that's good because it occurred after my Frank's briefing came. So I didn't get a chance to respond to that yet. All right, let's start with the grand jury subpoenas. And yeah, we wanted those in discovery. We didn't get those. We were told no a couple of different times. The issue with that is that at least one of the warrants was used, the returns from the grand jury subpoenas, it used the return from the grand jury subpoena to obtain information. And we don't have those, so we don't know the scope and parameters of that. So the magistrate relied on something that's not reviewable by us. And that's kind of gotten to be.
Amazon.
What?
Amazon.
It is Amazon, Your Honor. And the return on the search warrant says that they already produced them pursuant to something else. And the affidavit says, we saw these things, so now give them to us in a search warrant. That just seems to be problematic to me. It's kind of the same thing that's laying on pretty thick here. You can't have it. We're not going to tell you about it, but don't worry, we didn't do anything wrong. And that's a problem. That's a theme of this case, and that's really a problem. So I think we should have a Frank's hearing to explore what that really is about, if for
What's
nothing
the
else.
omission that, or the misstatement that you're, as it relates to the Amazon?
Right.
um,
The answer is I don't know because they didn't produce it.
Question, is the FBI used the grand jury system and obtained this information outside of the warrant process, but for some reason we need to come and get a warrant because nobody gets to, I have them in other cases, Judge. I don't know why they're withheld here. It makes me really
Well,
suspicious.
I mean, I guess from a Frank's perspective, though, the question is there a material
Misrepresentation to the grand jury.
statement or a reckless misstatement?
From Frank's perspective, was it material? Well, it was relied on to get the warrant, right?
That's not what he's asking.
Disclosed to the magistrate that this was the result of information given as a result of a federal grand jury.
It absolutely was.
What did they say that was not true, or what did they fail to disclose?
I think they failed to disclose the parameter around that grand jury subpoena.
Whether the information fell outside of the scope, it seems she's saying.
How is that? Well, I understand. I promised I wouldn't slow you down, so I'm going to let you just go ahead.
Okay.
I'd be like, no, Judge, please slow me down. I want to address every question in your head.
I'll go backwards.
Can you turn the volume up,
7
babe?
minutes that's not disclosed, that's intentional, that's not given to the magistrate to make the decision. There are a lot of these things that are intentional withholdings and a lot of things that are deliberate. You heard a lot earlier today about the hours of meetings that took place and the decisions to keep certain things secret. So I think we've satisfied the prong of deliberate and intentional withholding from the magistrate or deliberate false statements to the magistrate on all of those areas. I want to talk only about a couple of other things. The credibility of the witness that they talked to, the one that they cited information from, that was relied on. That appears in these affidavits, and it's relied on after Mr. Kohberger's identified to say, well, he has bushy eyebrows, so this person has to be right. It's relied on when the police officers put into the affidavit the footprint that I didn't talk about on my first one. We gave the court the photographs of it. I'm happy to give the court these. That's a misleading statement to the court or to the magistrate that was asked for probable cause. This footprint is at the very edge of the door. It's a single footprint and it's not repeated throughout the house. So to act like that bolsters this witness is really important, especially in context of the misstatements of the witness. I want to go through these. I won't read them in their entirety to the court, but Your Honor asked the prosecutor what they were. And I counted up, and at the very first interview, remember the issue was whether or not one of the victims ran downstairs. And she didn't say it once. She said it
I turned myself down, by the way.
4 times in a row in the very first interview. And that just didn't happen. It just couldn't have happened. And that was not told. In fact, that statement was brushed over and withheld from the magistrate. About the memory issues in the second interview the same day, there are 2 references to not remembering. A couple of days later, there's the third interview, and there's references to not remembering, being drunk, a statement, I don't know any of it. Like half this stuff, I don't know if it's a dream or if it's real. That's at page 399.
Is my
At page
sound better?
406, I don't know if this was real or in my mind was just like playing with me. But from what I think I heard, someone was crying in the bathroom. These are definite statements that were not given to the magistrate and in fact were brushed over. And credibility is really, really important when that person is relied on in the investigation. So let's talk about the vehicle. The court asked some questions about what the magistrate could see in the PC affidavit. The way it's laid out would cause one to think that the vehicle's identified on the camera near the house, and that's not so. It's not identifiable. The state's expert said it's not identifiable from that particular video. It's piecing together the other videos that they come up with something.
What's the evidence that law enforcement relied on the Ridge Road footage to identify the vehicle?
What did they rely on?
What's the evidence that they relied on Ridge Road, which you say doesn't show anything? What's the evidence they relied on that to ID the vehicle?
They relied on the Ridge Road camera, and you can see that in the emails from IMO and the other law enforcement officers when they say they have Paradise Creek Road, and then they say we finally got a good one, and it produced to us is the 1125 Ridge Road footage and photograph, and that's the only one that you can make a positive ID on the car.
Where is that in the record?
The 1125 Ridge Road. Well, it's in our discovery.
Or is it in the motion?
I believe we put a picture of that in our motion. I can look at it's in my original memorandum. I think there's a picture of that. Let me grab that page for you.
Does my sound any better, guys? Is it low enough? Is it in the box?
It's in one of these stacks. It should be this one. Your Honor, I believe it's on page 17 of the amended memorandum.
No public in the courtroom.
That's just the photograph,
Yes.
but not the information that ties that to the Ridge Road camera?
The emails.
Your Honor, it's tied by our argument based on our review of the discovery. I don't have an affidavit from any police officer saying it was that. I probably don't have an email other than the ones from Immel and that transaction that we did provide for the court.
Give
was
him that
the
exhibit number.
video that the identification was made on. That, I'd love to know more about that as well, Your Honor.
Well, but that's not the standard.
I understand that.
No,
I
remind him
understand that.
you produced
I would
copies
refer
of the email.
court to our exhibit with Agent Immel's communication.
There you go.
I believe that is going to be at D9, and then the pictures contained in the Frank's motion. Let me talk a little bit more about IGG, even though we've done that all day long today. I would remind the court that IGG doesn't identify a person. It suggests a family group, and an investigation can happen from there. but nothing happened until the IGG happened behind the scenes and in a closet.
He might not.
That brings me to talk about the intentionalness of this in an overview. And the court should look at the entire picture of what's happened. It's a long investigation. It's a complicated investigation, but you have law enforcement repeatedly meeting and you have FBI agents sprinkled in. And there are a lot of things that you've heard about today that are withheld, that are super secret, that nobody's going to talk about. And there's a lot of meetings that are happening, particularly around the IGG. That's a definite, we're not going to put that in there. But there's also the communication about the AT&T records, about what do those phone records mean? What does it mean when there's calls being handed off or phone tower reporting being handed off to track a vehicle? What does that mean? There's communication about that. There's review of the videos together. And what these things mean is that a partial picture was decided upon, a picture that left out a lot of detail, a picture that gave false statements to the magistrate to get probable cause to get that first AT&T warrant. That was, the officers went back and forth talking about what kind of statements to use. Statements were changed to be included in that, and definite decisions were made at that time. The decision was made to leave the witnesses' statements in as they were, even though there had been interview after interview after interview, and they knew those were incorrect. The decision was made to build a false investigation and leave out the super secret IGG part. And that decision was made based on the behavior of the agents and based on not wanting anybody to review what they did so that we could check their work and see if they did anything right. That just continued with decisions to leave things out in this case. Probable cause doesn't get determined by one little thing without context, especially when there's context of omitted information. That's why we have the opportunity for a Franks hearing, to ask for a Franks hearing and to offer information for your honor to rely on. It is imperative that there be integrity in the warrant process. There's a lot of power in going to a magistrate and having no attorney there, nobody to cross-examine, nobody to question. There's a lot of power in that to obtain a warrant. And there's a lot of danger when there's that much power too. To leave just a little out here, to add a little more here, and go get a warrant, and then build everything that comes from that. And that's what happened here. Your Honor, we ask for a Franks hearing to more fully explore these. The court can see this is a massive amount of information. The court has 1,000 pages. These aren't.
I don't know why it's doing
There's
that.
a lot going on here, and we need to have a hearing to fully explore this. Thank you.
Adjourn for today's motion related to the Frank's profit issue. Opinions on those forthwith. We will pick up tomorrow with, trying to think, we're probably at the evidence on the motions to suppress tomorrow, correct?
Yes, Your Honor.
All right, I'll see you in the morning.
I'll put my sound back. So I thought it odd she didn't circle back and argue, Your Honor, if the state, is relying on evidence outside of what the defense has, proffered to oppose the motion or the defense's arguments, based on the kind of the judge pointing that out, like if there's additional evidence is necessary to oppose or counter the issues raised, then the defense is entitled to a Franks hearing. I was actually trying to find something about that, just procedurally.
That has to be Idaho specific. 'Cause
I was looking in Iowa and I wasn't finding anything.
yeah, it's got to be Idaho specific because it's not what the law is. I mean, my confusion a little bit with this, and maybe it's because we didn't get to hear evidentiary wise like, I wish that they would specify exactly which warrants they're talking about. There were many, many warrants in this, because if it's not relating to the DNA on the sheath, which the judge was very much giving pushback on, he's like, look, I honestly don't give a shit what else was going on. If everything else was wrong, the DNA for me on the sheath is enough to where I think every magistrate that I know would issue a warrant. So if we're talking about
Correct,
the
but
arrest warrant,
she specifically said, and he said, I understand your arguments on the earlier warrants, but once you get to the arrest warrant and the connection of his DNA on that sheath, you can't tell me any of this other stuff matters. And, in theory, she could have conceded that and said, but they would have never gotten that without all the other, without the unlawful searches prior.
that's
Uh,
what her argument should have been, and she
I
didn't make that argument.
No,
Not
she did. She did. She said, "I hope you shouldn't even have to get there, but if you do get there, here I'm going to tell you why that doesn't matter."
Sometimes you got to say that when the judge is giving you that kind of pushback with that exact statement, you shouldn't have to be reaching for her making a roundabout argument. You just say it flat out. And
Right.
she
She
didn't.
should have just conceded like the state did. The state said, "Well, yeah, if one of the
Right.
other guys lied, then, you know." Um but she also, I was shocked to learn, like, to me, the reason I said it's reminding me of Sarah Carball, and maybe I'm misunderstanding the timeline of what she's saying, she being DM, um, that she heard the victim go up and down multiple times. Does that change the whole timeline? Is this after she saw the person leave? Like, why are you telling the judge she said all these things that are not true, instead of saying what she said, if true, changes the entire timeline?
Massively.
Right.
Massively. That means that
That they
one
were
of the two,
alive still.
yeah, one of the two upstairs got out of the room. And
Right.
why would they go back up there?
Right.
Like if the killer's up there.
So that the reason I was relating that to Sarah Carball is because I just have so much PTSD that the defense didn't lean into her as being accurate and saying, see, what she says, proves it could not have been, Richard
Richard Allen.
Allen, instead of saying she's making shit up, you know.
Right.
And I felt like that's what they should have done here, because the credibility of the witness, I mean, in one sense, uh, the reliability of a tip is different than like the credibility. I don't think that the credibility is as strong an argument as the facts are inconsistent with what the judge was told, and it destroys their entire timeline kind of argument.
My
And
position with DM always has been, since the minute that probable cause affidavit dropped on the arrest warrant, was she was shit faced. She's been out all night. She's hammered. Like, now it's confirmed that she was hammered. She's a college kid. Like, does anybody remember being in college? When I was out all night and I rolled in at whatever, 1:30, midnight, depending if I was day drinking, which you do a lot in college.
so I want to ask you this, because you felt that the probable cause affidavit in this case leaned heavy. It had a lot of facts that speak to probable cause and um, implicating Kohberger specifically. Hearing these new facts, does that change your overall position of that probable cause affidavit?
I mean, look, the bottom line for me, and it's obviously pending trial to when the evidence is challenged. I could come up with a million ways that there would be unknown blood on a railing. That could be
At a
from
party house,
who
who
knows? Who
knows?
knows? It was a party house. It could have been ancient. It could have been anything. I am hard pressed when you're talking about a murder scene like this, where it was clearly a knife that was used, to think how that sheath would have gotten there. And it's a real stretch. And I'm talking about from the jury's perspective. not mine, y'all. You guys need to.
What about the
whenever
bloody
I'm-
gloves outside that aren't has unknown DNA on it? That's different than the banister.
Wait, I
There
didn't
were
hear
bloody gloves found outside with unknown male DNA. I think it was.
bloody gloves. I heard there was DNA out there. I didn't hear the bloody glove part.
Maybe I just added that.
No, I don't.
No, I might have. It might have just. I thought there was blood on the glove, but maybe
You got
there's
some
not
OJ
blood.
shit going on now.
I don't know.
I did not hear that, bro.
Somebody fact check me. Was there blood on those gloves or just DNA of another person? And then to me, like her trying to weasel, her being the prosecutor, trying to weasel out of the cast guy, placing him in, phone stops, he was heading in the right direction, and then no, wait a minute, he actually had started traveling a different direction 7 minutes prior to that, and you didn't inform them of
Well,
that.
Let me put it this way: if the DNA sheath doesn't exist, I don't think they have probable cause.
Well, the DNA sheath we have to assume does exist.
No, I'm saying in a world in which that does not exist as being found under one of the bodies, they don't have enough probable cause against Brian Kohberger. That's my
Okay.
opinion. So that's what I'm saying. Like for me, that begins and ends the case against him. And for a jury, what I'm telling you, I don't give a shit what people are saying in the chat. I don't care what people, touch DNA, it's easily transferred. I get it. But if you know anything about jury trials, that is absolute smoking gun evidence. You can say that all day. Man call Clady. man called lady. I see. But that's not how it's gonna work with the jury. Trust me, it's not. We've been doing this a long time. That this
Yeah,
is
it's called Clay.
this is DNA evidence is going to be very, very difficult.
Well, we don't know yet. I mean, once that's the whole point. It could be BS. It just depends. Like,
Well,
just because they're saying
how could it be BS?
in all the ways in every other case where it's BS,
Give
where
me an
there's,
example.
Garcia, anytime that they're stretching the examiner is like stretching where the peaks don't match up, where they're taking a
That was
minor.
a 1 in 12, and there were multiple contributors. This is a single source sample.
Yeah, if it's single source and it's all loci, then yeah, I mean,
I'm just
but we don't know yet until we see it, until they
Well, we know
challenge
it's
it.
single source. That we know.
And that the state says it's single source.
What?
We know that the state claims it's single source.
I
I
mean,
mean,
that would be a really weird thing to lie about.
well, not to lie, but that's the way so and so interpreted it. I mean, I don't know, but I'm just saying just overall, does it change your overall opinion of the strength or no because of the DNA alone?
I mean, no, because of the DNA alone. That's what I'm saying. If you took out the sheath, I don't think they had probable cause against Kohberger. But
Well, it
like
changes the car that they saw his car driving in all these places. It changes that he was traveling these places, and now it's almost just the DNA.
I mean, are you asking me as a defense attorney, or are you asking me if I'm a juror?
No, I'm asking you, Bob Mata, who felt so strongly about the PCA. Does this impact your opinion of the PCA to any extent?
Not really. I mean, but
All right, well then,
it begins and ends with the sheath for me. Like, I don't care what anybody else is saying about it. Like that is just
well, for
a very,
preliminary
very
hearing, for probable cause, yeah, and without
100%.
it being open to challenge yet.
Well, yeah,
Stop-
I can't speak to anything else because none of it's been challenged. But based on the probable cause and that very low standard, I mean, that is a very difficult piece of evidence that it's as bad a fact as you can get. Like no lawyer wants to deal with that bad fact. No lawyer wants to deal with that fact. It's like, I mean, you can have bad facts in a case that you're trying to work around. And I assure you, the one piece of evidence that is of the utmost concern to Ann Taylor is the DNA on the sheath. I mean, you could pick apart the rest of it like she's doing, I mean, it's like the tower stuff, the car, that they gave her I mean, that's all going to be stuff that she could pick apart, but that's at trial, but the DNA is going to be the one thing that there is going to be a real issue with the jury, because jurors are just very CSI minded. And, that's just how they think. They don't understand it in real life. You know what I mean? So it's very powerful evidence that is going to be very difficult to deal with.
Right.
What about you? I mean, do you like?
It definitely changes my opinion on the strength of the probable cause affidavit. Whether there was probable cause or not, I don't know. I'd have to like revisit it and reread it. But the fact that there's someone awake and going up and down the stairs, the fact that that there's one video where I just like, because I kind of can't grasp it. Is she saying all the other videos show a strikingly similar car, but it's in only one of those cars in one of those videos that you can see that it's an Elantra? Or is she saying you can't tell shit about this other car that they're somehow trying to play is the same car in this other video, and this other video where this car is seen so clearly is not even in the same general vicinity as the house.
I mean, to me, the
Wait,
more
and there was one other thing she said, and that in the video where you can see the car, you can't even see that there wasn't a front license plate. So when they're saying that there wasn't a front license plate, they have no basis to say that, because that they don't even know that the car in those other videos are the same car. But like I said, I could be over leaning into the defense's argument more, and maybe the video, it's like, well, clearly it's the same car, you just can't see it as clearly as you can in those other videos. But the defense is trying to argue that's it's not even the same car.
I mean, for me, I never gave any weight to Dylan's statements anyway. If you remember, I thought that I said it early on in the first podcast I did on that thing, when I read through the entire thing, and I did an entire episode on Dylan's statement, that I thought that whole thing was made up out of whole cloth by law enforcement. Her whole statement, starting with the frozen shock phase bullshit,
Yeah.
like I trash. So that had little weight for me, like the more powerful, taking away the sheath. But if
I
you're
was
just
hoping to
talking about-
hear her say something like she didn't exactly describe the eyebrows like that until later, or they put it in her mouth. I was kind of thinking to hear that, and we didn't. So
do we
as
even hear the mention of eyebrows today at all? Bushy eyebrows? I mean, you
not
and
in
I
their
were saying it. I don't
right,
remember either.
not in their closing, which makes me think that she sort of the way the judge made the analogy. Well, when the affidavit doesn't say, for example, we found DNA in the car, we found DNA in his house, or doesn't say, for example, we were able to match up that shoe print to his foot size, doesn't that imply to the judge that they couldn't do it? Bodes the same for the fact that she didn't mention the bushy eyebrows. If there was any question of whether that witness described them as bushy or was asked it first, I think we would have heard about that. So I'm going to assume, from the fact that we didn't, and again, it's just an assumption, an educated guess, that the witness in fact volunteered that the eyebrows were bushy.
Yeah, I mean, I've seen a lot of pictures of him. Now, I don't have bushy eyebrows. I've seen some pictures of Brian Kohberger where, they look like caterpillars up there.
They look like what's his name's?
No, nobody looks like Luigi. Now, those are bushy eyebrows. But look, I mean, at the end of the day here, it's like, I'm just telling you.
So here's the answer to the question everyone wants to know. Do we think he's going to grant a Franks hearing? I think he's going to find that the statements about the direction of the car were um, misleading and maybe find a couple of other things or omissions. But then ultimately, it seems at first, it seemed he was leaning towards finding none of that matters. There's still probable cause. Definitely, obviously, when it comes to the arrest warrant. But the question depends on, was all the other stuff, he may say there could have been nothing left in this warrant, and it could have just said that in the house where the people were stabbed, underneath the body was a knife sheath. On that knife sheath was his DNA. And if that is enough, then I needed nothing else. But if he says, well, the only way they came to identify him to even compare his DNA was through unlawful IgG, which I'm not sure. I mean, he seemed like he was at least floating the idea about if the FBI did anything wrong with the garbage, but so at the end of the day, that becomes the question. If the direction of travel and when the phones went off wouldn't have changed the whether there was probable cause for whatever warrant though that information was included in, and then without the information from those additional warrants, what would be left, that's the analysis. And I think he took issue with the prosecution.
He was hard to read, though.
But
You know
the
what I'm
prosecution on 2 different occasions proffered evidence not part of the Frank's hearing to say she shouldn't grant a Frank's hearing. And I think that was a lot of his shaking his head. He's like, God, they keep saying, I already told her, don't offer new evidence. And then
Well,
when he said,
she didn't need to say anything.
Well-
He showed his hand until she started saying shit. That's what raised the issues for her. He showed his hand.
Right.
You and I both know if we were sitting in that courtroom and we heard him say, and he has a real appellate court judge vibe.
yep, he
Because
goes on both sides.
right. So it's like, I can't glean anything in terms of what he's thinking other than the fact that he made a very declarative statement to the effect that, look, that DNA on the sheath that matches the defendant, I don't know one magistrate that's not gonna say that that's probable, that's not probable cause. I mean, that was to me the most telling statement he made. The pushback on both of them in terms of various points are one thing, but that thing in and of itself. But that's what I'm saying. We got to pull up the statute out there to see it's a difference, because the way that we're used to dealing with Franks is if even if you have all the lies and you pull them out, does there still exist enough probable
That's
cause?
definitely the way it still is here. I mean, he mentioned that, but if you need to look at evidence outside, and I guess that's true for us too, because the prosecution doesn't proffer evidence outside of the 4 corners of the affidavit to overcome a preliminary showing at a Frank's hearing. But I've just never heard it kind of presented that way, and it was interesting that when he said, and to her, after having forewarned her, so, and how do we know that's true? And she says, from, this additional information, my response, he's like, oh, I was afraid you were going to say that. I already told you, don't say that. So, who
Well, because
knows?
he made the statement that would require a Franks hearing.
Right.
If she continues to say things like that. I don't know. I mean, the hope is with the Franks that the thing's going to get dismissed, and I can just tell you right now that's not happening.
Right. And the
So-
judge is not going to want to waste his time to give a Franks hearing just because the state, spoke about other evidence. He'd probably figure out a way to work into, I ignored the state's proffer of this. He would be saying all of that if he's not going to grant a Franks hearing. And, this is what Bob and I are used to. This is what we think should have happened in the Richard Allen case, that she should have held a hearing to determine whether there would be a Franks issue. But what Judge Gull presumably was doing there was saying, if I accept every single fact that the defense has proffered as 100% true, they lied about this, they shouldn't have put in this. If none of that would even for a second change my opinion, I don't even need to give them the the preliminary hearing. But typically, you have these little preliminary hearings to determine
Yeah,
has the
and
defense met its
this
burden.
was not little. This took all day. You know, I mean, they made a record. That's the important part about it, is being able to make a record and being able to put witnesses up there to make a record. And you know, I mean, Alan didn't get any of that. Like the judges that have been presiding over Kohberger are night and day, in my opinion, more effective than Gull was on that case. Like, I mean, she just didn't handle it like a normal judge handles anything. It was like it's like that was the whole reason. I can't trust that verdict because of the way that the whole process took place. And you know, I mean, look, like Osbrook texted me today. I don't. Did anybody see? Did she deny the motion to correct error already? Like Osbrook said something to me, but I couldn't read it. And then I texted him back, and he didn't. He didn't. He didn't follow up with it. I'm like, wait, she denied it. So I can't imagine that would be pretty quick.
Let me see if I got anything.
I didn't get anything from Renee, so Sleuthie would know if there had been some kind of order that came down.
But maybe you shouldn't be talking about your guys' chat messages anyway.
Who?
I don't know if he knows something that you don't know.
What do you mean? No, like that. Like, how would he know? He's not an attorney of record. He could only know. Like, what do you mean? How could anybody know unless it's in the system?
Right.
I mean, like you think she's giving courtesy calls to the defense team? Hey guys, just wanted to let you know I denied your shit again.
No.
Yeah. So
All right. Well, what are we doing from here?
okay, so here's the way that we're gonna have to play it tomorrow. I don't know what, if anything, they will stream tomorrow. If it's kind of the same approach tomorrow, which I'm very much anticipating that it will be, in terms of evidentiary stuff is going to be closed and then they'll open it up for argument, because that's all we saw today was argument, and it was substantial. It was good. I was glad that we got that at least.
As soon as they go live, we'll go live.
Point where Ann let slip on something. She said that like got into the DNA and then she cut herself off real quickly. Do you remember that one? It was like
I don't
one
think I was
part.
here yet.
No, yeah, you were here. This was in the last half hour. So I don't know. We'll do that. I still want to hear the end of the Richins stuff. Frankly, I think that, to be honest with you, I think that those motions to suppress have more legs than these do.
It sounds like that's the end of the Franks hearing. The judge is going to rule. No, I'm sorry. That wasn't a Franks hearing. That was a hearing to determine if they have met their burden to entitle the defense to a Franks hearing.
Correct.
But so that is over, is what I understood. But there are motions to suppress pending that are going to be heard tomorrow.
Right.
Bob, also, people are asking, are we going to do anything about the Karen Reed docs?
Yes, as soon as we get them. Tracy
she sent a text.
Yeah, it did. So Tracy said that she said that she's not seeing, she sees other documents relating to it, but not the actual motion to dismiss yet. So I don't know. Tracy will keep looking if it comes down the pike, because it sounds like it's coming from a tweet where it's from Aiden saying, breaking news, a motion to dismiss for extraordinary governmental misconduct is forthcoming from Karen Reed's defense. Has anybody seen
I've
these?
been waiting for one. I thought they should have done that in their very first thing that they filed with that would have, like, they were going to do like a mini appeal from. But
yeah, so we'll keep an eye on that. So just figure, and remember they're mountain time out there.
Emily says Melanie already did a live with them. She's got 2 docs.
Oh, we'll text her, see what she's got.
Okay.
And we'll see. So yeah, if we can do, because what we'll end up doing, if we have to wait for whatever's going to go on in Kohberger, we'll go through the the read docs if they're out there. All right, so I think that's it. Yeah, we thank you guys. We know we had a lot of streams today. It was kind of a clunky day court-wise just because of how courts are handling things and the Richins thing. We only got audio on this. We only got what they were willing to give us, so we didn't get to see the actual evidence, but we got to hear them talk about some of it, which is good. So, all right, you guys, please make sure you share, like, subscribe on the way out. If you haven't listened to Murder on Songbird Road, episode 4, drop today. If you're subscribed to whatever iHeart Plus, you get episode 5 as well. We feel like it's worth your time. Lauren and I both do. I think it's a pretty good podcast. Pammy, I was wondering where you were at all day. We missed you too. So, all right, you guys, make sure you hit your notifications so that you'll know when we're going to go live tomorrow.
And we'll start when we see them live. We'll start, and then you
Yep.
guys can catch up.
All right, you guys are the best. We love you all. Thank you, Crypto, for Crypto and Make Up with Jack, or Make Up with Jackie, or Make Update with Jackie. Thank you guys for your
Super chat.
generosity. We appreciate it. All right, y'all. Thanks, guys, because without you, I'm just an old man.